Yes, sir. Now video on. I'm able to
Yes, sir. You are visible.
audible, huh? Okay.
Yes. Good morning, friends. Good morning, friends. Welcome to CBOA promotion class. Today session is recovery policy. This will be handled by Shri Satish Kumar, sir. He is handling advances in Tambram RO, and previously he is a faculty at RSTC Kolkata. Welcome, sir. Thanks for your precious time.
Thank you.
In spite of all his official engagement, he has joined us. So please start, sir.
Can you allow me a screen sharing? Not coming,
Yes, sir.
yes. No, it's coming. Fine. Uh, Whether we will be waiting this or for a few
Sir,
more minutes, or
we
shall
will,
we
we will start, sir. We have,
10:03?
yes, sir.
If the audio quality and video is okay,
Yes, sir.
screen
Everything
shared,
is fine.
screen shared. In between, any you got any voice is
Message
not
like
clear.
that.
Somebody is messaging. Voice is not clear.
I
Check few
think
more
for
text with
others,
the
it's okay.
participants. Madam Pooja, you just try with the login.
He is saying to increase system volume, sir.
The volume as per the Zoom is okay. What about your side?
Sir,
Bisilva?
my side, your voice is loud and clear, sir.
Loud and clear.
Yes, sir.
Madam, can you check with the test with re-login the session? Okay. Now screen is in the share mode only, no? Silva?
Yes, sir.
Okay, okay. Very good morning to all of you. It's a weekend time and definitely it's a preparation time. So we'll start with a very great motivation and a very great motivator, Sri Swami Vivekanand ji. The words arise, awake, and stop not till the goal is reached. So our goal is to get the promotion. So your efforts should not stop, and and whatever learnings you are making, you should not forget till the exam is over, and after that again for interview. So with that great motivation, with the great motivator Swami Vivekanand ji, let me start this session. The Silva has introduced me already, so they not do again introduction. Again, who has joined later. My this side Satish Kumar. My name is A. Satish Kumar, DM RO Tamram. Looking after advances, you might be thinking that advances why he is taking the recovery classes. So recovery is one of my favorite subjects. So that's why I am taking this, and I've been a faculty when RSTC Kolkata, so CRM recovery used to my topics. I think
Sir,
somebody is
your
talking.
screen is not visible now, sir. Can you share once again? Now it's
Got
fine, sir.
it?
Start. Yes, sir.
Okay. I think some audio is coming in between.
Okay, sir. Now I think it's fine.
You can mute all, no?
Yes, sir.
But should not mute me. No?
Yeah, yeah, sure.
Okay. So once again, welcome to the session, morning session on the recovery. So arise, awake, stop not till goal is reached, and we will be arise, awake, stop not till the session is reached to the end. Okay. So my topic on recovery policy. So basically, the recovery policy, what has come in the March, and the few modifications we have seen in this policy. My main agenda and the main topic will be on that, and with very much focus on the SURFACE Act, where we have some amendments and changes that we will discuss. And when specific circular on SURFACE has come into the picture, and that would be one of the place where we think that the examiner may ask the question. And last time when we have seen the questions in 3 to 4 and 4 to 5, Almost 20 questions came from only recovery policy. Very big type, very small questions, few amounts and yeah, only remember type question. But it was mainly from the recovery policy. So this time also expectation is there as the policy has got some minute changes are there. And we think that this policy holds good and that which fits in our examination policy and maybe examiner will give more priority on this as a recovery. The point in our the screen is again
Sir,
stopped.
once more.
Post to disable the participant screen.
Sir, now you do it, sir.
Got it?
Yes, sir. Yes, sir. Visible, sir.
Fine. So my points of discussion, which I told recovery policy, the circular which has come in March itself, that is 247/24. And I told already the surface new changes has come, some support SOPs has been given. So that is 421/24, 544, some modifications, minor modifications. And we will touch some points like in policy, Mecha there, it is a 279 pages of policy, which I tried to crisp in 78 slides. So I'll try my best to make you ensure that you will be getting the crisp on the policy and the examiner point of view, what will be the important we'll share, as well as on the practical aspects. So for service, we'll deal the practical aspects also. Those who are going to be a scale code, they will going to be the authorizing officer. So think that this session is the session to make you prepare for how being an authorized officer, you are going to tackle the situation. So before going to that, from participation side, I would like to make some assessment. Like I want to ask some question, and you can give me an answer in chat also. Uh, I hope you know the concept of NPA. Okay, what is NPA? You can share your answers to the chats in between. I'll be seeing the chats also, like how you are going to give me an answer on that NPA part. So, what is NPA? First of all, question is what is NPA? So I can expect your response in the chat box. So what is NPA? Non-performing assets. Okay, it's a basic question. So from scale 1 to scale 3, everybody might be knowing. And when we are telling non-performing assets, I think last time already sir has taken the class, Jagannath sir has taken the class on the OTS and all and IRAC norms. So I expect that you already have an idea of NPA and when it becomes NPA, somebody is already telling that yes, it's interest principal due on 90 days. Very good. It is on the term loan cases. And wherever ODs are there, we have an NPA in the mode of technical NPS. We call it as a technical NPS, where interest is not, where credit is not happened, where you have not given the limits. These are the technical NPS. That is called out of order. Very good. Somebody, Prasna is answering. And when expected income and accounting also in this case of like in our IRAC norms are might have dealt with. So what is IRAC norms? IRAC. I'm expecting your answer in chat box only. IRAC. IRAC. IRAC, you might have already gone through the session because I want to check income recognition asset classification where your SS has answered. First answer. Dear friends, income recognition asset classification, absolutely correct because when we are when our accounts are giving us interest, performing assets means giving the income generation to us, on those cases, we are doing the accounting on the actual basis, okay, or we can say the accrual basis. Means if interest has come or not come, we are taking into account till that 30, 90 days. But on the 90 days, when it becomes NPA, so the interest which you have accrued, you are not considering into the income, and we are not calculating in our balance sheet, and we are calculating only the portion of the principal which is outstanding or the charges which are debited. That interest, what you are showing, seeing for the NPA accounts in 7026 balance, and maybe the scale 1, scale 2 may not have this concept, or may they have some kind of a classification. So where you have the chat is disabled or you want to disable the chat, Manish? Okay. So where the income we are considering is the accrual basis, and when account becomes NPA, we are not considering those income. So I hope then this class, whatever taken, it has gone rightly. Your people are able to answer. So I'd be going to my session directly. So without making any other. Now, what is the objectives of loan recovery policy? Why a bank should have a loan recovery policies? So you know the NPA. What is NPA? You already told. But how NPA is affecting the banks? Why we want to reduce this NPA? It's just like a double-headed sword for us. Okay. To one side, NPA is eating away our profits, and another side, NPA is eating away our capital. So this is how the NPA is affecting us. So that is the main reason why.
Okay, okay.
Uh, that is the main reason why bank whole has an NPA policy and a recovery policy to recover these non-performing assets. Why? Once you are recovering non-performing assets, we are releasing profit to the system. Also, we are releasing that capital to to use that capital for the fresh finances. So when I'll come to the OTS portion, I will discuss in deep in that how it is going to affect and why OTS are important at the time of importance. I will definitely discuss. So our recovery policy says that it is minimizing the acceleration of fresh NPS. What are the NPS we are adding day by day, SMA 1, 2, then it becomes NPA. So we want to minimize the acceleration of fresh NPS. Then next comes the upgradation of existing NPS. Upgradation of existing NPS, again the same thing. Like when we are reducing NPS, you can reduce by way of recovery, and by way of upgradation, you are doing far more better for the situation. Say asset of say 100 rupees. When you are recovering 100 rupees, you are also recovering the business. That means 100 rupees of the business is going down when you are recovering full 100 rupees. Although your 100 rupees is getting to the profit if it is the D4 assets and all. So 100 rupees is also going down the business. But when you're doing upgradation, same 100 rupees, when you're doing with the minimum payment of say overdue portion and you're doing the upgradation, so your business is simultaneously is intact. It is not going down. You need not to again search for the new MSME loan because again the call will be there from the your HO side, the circle side or the RO side stating that hey, sir, your business has gone down, you have to recover. So upgradation is one of the aspects where you have to focus in case of NPS, and we can target soft NPS in this case. What is soft NPS? Soft NPS are NPS which is recently happened 2 or 3 months before only slippage, and the chance of recovery is more in those cases, subject to if they are not repeated restructure or the restructure accounts. So otherwise, the chances will be more that it will be recovered easily. Okay, then recovery policy is also the objective of the recovery policy is also to enforce of security as per the provision of SARFAESI Act. We will deal this act very briefly in the next slide. So just remember that enforcement of SARFAESI Act is one of the aspect of objective. Recovery through legal actions. Legal actions means courts, DRTs, also including local adalats. Enforcement securities as per the terms of the loan documents. That is in respect of documents where it is not covered under SARFAESI Act. Because when I deal with SARFAESI Act, I'll tell that when we are dealing with the SARFAESI Act, we are doing the job as a secured creditor. Means we have a right from that property. But what about the properties? A person is having two flats. One flat is given to you as a housing loan and got NPA. Okay, and those that NPA house, whatever it has happened, you sold the house, but still you could not able to recover the proper amount. But what about the other house that you can sell it on the surface? No, because he has not mortgaged us. We don't have any title right as the secured creditor. So those cases, how to attachment that also includes the recovery policy. Recovery by compromise settlements or one-time settlements, invoking ECG, CCTMS, wherever you have covered CCTMS, ECG, FMU, ECGs. So these cases we have to invoke to get the money. That is the one kind of a recovery. Minimize provisioning by improving recovery. That is objective is I already told that an NPA is affecting double-headed sword. It is affecting the profits by way of provisioning. It is also affecting the capital. So provision is what? Whatever the when you see the bank balance sheet, you see gross profit is say 1,000 crores, then net profit will come to be around 800 crores. Why? That gross profit minus that NPA. So gross profit that NPA is our net profit. So that is what the balance sheet says. So we have to minimize that provision for that recovery is needed. Sale of NPA to ARCs. ARCs is asset reconstruction companies. Asset reconstruction companies. These are the companies who purchase NPA from us. So you might be thinking, what is the fun over there to purchasing NPAs? Yes, it is a kind of a business where ARCs will purchase NPAs from the bank to take the burden of the NPAs from the bank to theirs. They will take care of the recovery. Okay. Sale of purchase of NPA to other banks or NBFCs, same concept of ARCs. So, but in India, ARC was not very successful compared to the countries like Vietnam and all. So when you see the data of Vietnam and those countries, ARCs has got good concept. India, IBC has gone hit. It has given a good result, but ARC's concept was not very much successful in India. Implementation and adhering to the guidelines prescribed to the bank, RBI, government time to time. So that is the recovery policy also gives the you know statutory guidelines, or you can say the compliance guidelines on what RBI is telling, that how to do the recovery, what to follow, what not to follow. These are the objective of this policy. Guidelines on review and monitoring and follow-up NPA. And second is review of the delegation powers. You are giving OTS, or you are settling the account, you are giving waiver of legal actions, or you are purchasing some assets, non-banking assets. So in these cases, who has the delegated power? The objective is covered in our recovery policies. Then elevation of non-recoverable loans. Then the loan which you have tried every aspect, but you could not able to recover. So what is the fate of those? Okay, so that is the elimination of the. So that also is this policy is discussed. I will deal with this when the prudential right of concept will come. I will deal with this slide. Issuing guidelines regarding the empaneling and engaging the third party agents like recovery agents and lawyers, DRTs lawyers and court lawyers, what we are empaneling, what to pay, make the fees, how to make the payment of the fees, because these aspects are very important. Last year, whatever the questions has come from these aspects only. So, Silva, who is making this line? You are making, huh? De Silva?
Sir? Yes, sir?
This lines on the screen, who is making?
No. I
Text
think,
and line.
okay, somebody is, okay, wait, sir. We'll cancel that. Some person I couldn't, if I'm going to
I think 1
stop.
minute, Ravi sir. I think it is Ravi sir, I guess. Hello? Okay. Okay. Okay, next coming to the screen of non-legal methods, which I already told that recovery includes legal and non-legal methods. So objectives I have covered most. So there are two criteria. One is recovery in the way of non-legal methods. Another is the legal methods. So non-legal methods, we have a settlement through compromise, invoking ECGCs, NPS, the sale of NPS to asset reconstruction companies, sale of NPS to banks. So the questions may be asked like that. Which of the following is the non-legal method? Which of the following is not under the non-legal method? So they will give the four option and another option from the legal method they may give, and you have to choose the which is not. So this kind of the conditions which may arise. So for the knowledge sake, you have to understand this. So the slide is moving.
Slide is moving, sir.
Slide is moving, huh?
Slide is moving, sir.
It was not moved for us. Okay. Now, second comes is the what is the legal way of doing the recovery. So, legal way of doing the recovery is first filing of the suits in appropriate civil courts. So, there may be a chances the legal which is less than, you know that less than 20 lakhs we have to file in your district level court. So you have to file in the court. That is the legal way. Second, if it is more than 20 lakhs exposure, you have to file in a DRTs. If it is more than 1 crore, then we have one more option of the IBCs and NCLTs are coming to the picture. Invoking the provision through the Revenue Recovery Act. So this Revenue Recovery Act, when I'm speaking, it may be available in your state, may not be available in your state. So like in Karnataka, if you work, Revenue Recovery Act is very prominent over there. And if you go to other states, there is not much. Although the law is there, but not is followed up in that meticulously. And referring the cases to Lok Adalat. Lok Adalat is one of the way to settle the loan, but this is one of the question where examiner may ask, because Lok Adalat usually we think that it is a mutual consent, the settlement happen, and yes, it is mutual consent, but we are doing Lok Adalat in the court, and it is also a kind of a legal way of method. This you have to understand. Yes, Ji. They're calling up. Hello. Yes. Yeah. Tell me. I'm sorry, friends. Some technical difficulties are coming. So in this case of the legal way of method of recoveries, we are doing in the form of a local adalat revenue recovery. Local adalat is one of the option where examiner may ask and give you as one of the doubtful answer that whether to test the check whether he is able to answer or not, he or she. That local adalat is the one of the section where it is comes under a legal way of method. Although it happens because of the consent of the mutual consent of the both the borrower and bank. Okay, winding up the company, okay, and invoking the resolution process, I already told IBC, and invoking the provision under section 138 of an act. So 130 of an act, what is the provision we have is where you can say that uh, check we are taking for the nowadays we are not taking, but very old cases we used to say where the checks you are taking from the pre or the post dated checks you are taking from the customer for filing a suit if the customer is not paid. So in most of the private banks, you might have seen that private banks are very prominent in this. What they do, they take the post-dated checks from the customer. If you are not paying it, they will present this check with the overdue amount and pull the outstanding amount as a recall amount. And on the recall amount, they will file a case that it has been bounced by you. So this is the one case which it is also a comes under the legal way of recovery. So one is Lok Adalat, very specifically this point. Another is the check bouncing case, NI Act. These are all under the comes under the legal way of recovery, where we think that it may not, because NI Act is again it is not belong to the legal directly, and Lok Adalat we think that is a mutual consent. This may be a confusion, so try to ensure that you will be not giving any wrong answer on this. Next. Okay. Then what about the wherever suits has been filed? What is our job to do? Wherever suit has been filed, take the court order, interim orders, and also we can file the ABJ. The concept of ABJ here. So what ABJ is? The ABJ is nothing but attachment before the judgment. Like you have one customer. Just before one example, I have already dealt with you that we have a property where it is not created by your secured creditor, means, or we are not having any rights, we are not created in mortgage. But how can you attach the property? So what we can do this, we can give the details to the court before the judgment to attach this property if you think that the selling of the property or the resolution, whatever the resolution we are going to have, is not going to suffice the close the account. Then in that case, we can ask for the AVJ. Obtaining the decree and RC copies. RC is the recovery certificate. Usually DRTs will give. Filing the appeal and review and revise petitions wherever you think that a case is gone wrong in that case or not in our favor. Purchase of the sale of non-banking assets required in the loan. So these are all coming under the our recovery in legal part. Okay. Some technology associative, just for the examination point of view only, it can be very useful that to just understand that what the bank is doing and as per what. So we have a recovery mobile app and we have a call center which is calling the customers from book liability less up to 1 crore. So this may be one answer, question answer. The call center is doing up to what? So you can tell that book liability up to 1 crore, the call centers are calling to the customer directly for the recovery. This the slide is not moving properly. This logic.
The slide is moving, sir.
I am not able to see the slide. Now the slide is EOTS.
EOTS, online on-time
Okay.
settlement portal. Yes, sir.
Okay. So EOTS on-time settlement portal. So this is the one as per the ease norms government has introduced. It can be also asked under which ease 6.0 is the agenda on which government has told the banks that they have to provide the online settlements OTS in the online as a parity. Like if when the customer go and to the online portal, he enters his account number, customer ID, phone number, and all. It will move to the page and it will show the amount that this is the minimum OTS amount you can settle. And if he agrees on that, he has to click and OK and all. Then when he gives the consent, the settlement offer will be then he has to pay the 10% then and there itself, 10% of the OTS amount. Then next we can make the full amount as per the agreement time, maybe 1 month, 2 months, or 3 months. And next is the OTS sanction portal, which we are using in the SS package. So in SS package, we are entering OTS when it is sanctioned and all. So maybe the RO is giving the call to all, stating that please do the OTS entries. Everybody is doing by taking the OTS forms and all. So that is the one portion. These are the 4 technological implements by the bank in the case of the recovery, as per the recovery policies. Okay. So next, coming to the surface yet, as per the recovery policy, I already told that recovery policy we have already dealt with the legal way and the non-legal way. So surface is one such act. In what way you think it is a legal way or it is a non-legal way? You can have your answers in the chat box. What do you think, whether surface is a legal way or the non-legal way? Okay. That is why the question is asked. Most of the people are telling it's a legal way. So this to be considered as a non-legal way, dear friends, because SARFAESI is a one act which has come into the powers of the banker or in the hand of the banker, where he can do the recovery without intervention of the court. Okay, so act is under legal, but procedure is non-legal. Okay, it is not unless and until it touches the legal. So there are the legal separate procedure in the Surface Act is there, but Surface Act, if you see, it is first itself the definition will say that it is a without intervention of the court. So it empowers the bank and FIs to enforce the securities against the borrowers and realized due without the intervention of the court. There is no question of the court over here. So if you are following your procedure, you can sell the property without intervention of the court, without intervention of the DRT. If your document is having the proper limitation of time and your borrower is also cooperative borrower, and their intention is not wrong, then in those cases, what will happen? You can easily sell the property without the intervention of the court. So it comes under non-legal matter. It is a one powerful tool which bankers have received to make a recoveries, because it was introduced in the way back in 2002 and all, with after so much of amendments and all. The reason behind this, the bank was holding that time huge number of NPAs, and bank were not able to enforce the securities, because that time in every, like in agriculture cases, you have to go to the court only. So like that only, every assets bank has to go to the court only, then only he could save. Then the amendment has come in the form of the SARFAESI Act, and the SARFAESI Act what we are saying and what we are doing at the branch level. So, but before doing SARFAESI Act, there are few points which we have to ensure to make it a perfect execution, because this is a one such powerful tool where banker can sell the property of the one customer or the borrower, the NPA borrower. Even the district collector cannot sell this power. Those who are going to be a scale 4, see, as a scale 4, being a authorizing officer, you have such a power that you can sell a property of a one person. But even district collector cannot do that. So that understand this. So when the bank has been given such a power, so definitely with power comes the responsibility by Spider-Man, right? Spider-Man says, no, with power comes responsibility, and it's very true in this case. When the power comes, you have to be very much responsible. You cannot be complacent. Neither you can do whatever you can. Neither you can do whatever you want. It has to be go by law, by and page to page, everything to be intact. Because if it is such a act, if we are doing any wrong procedure with in this act, and it may affect the total bank scenario or the bank fame in future if customer goes to DRT. So what should be the first criteria when we are seeing the SARFAESI Act eligibility? Account should be NPA. Okay, first case, that is my account should be NPA. And one more question from this SARFAESI can be asked, and last time also it has been asked. They have given some 5 categories, told that which is not as correct as per the eligibility of SARFAESI Act. Okay, so these 5 things you have to remember, 6 things you have to remember in your mind. Without this, it is not possible. So first, account should be NPA as per RBI guidelines. Okay, then there should be a security interest created in favor of bank. What is the meaning of this security interest created in favor of bank? Security interest created means a borrower must have given the title for securitization. When you see the your documentation, your 490, 491, you are taking for what? They specifically take that I am intent to create my mortgage or intent to deposit my title deed with my own intention. This is a clear-cut lines available in those documentation. Please go and read once again. That intention of creation of mortgage should be very important in favor of bank. And that is the reason why we call it to keep the EMT balancing intact and keep the EMT ready, keep the EMT will be followed very specifically. That you also write somebody who's looking after the EMT, they write borrower has signed in front of me. Okay, you mentioned that and you sign it. Why? Because it gives that borrower has created. And it is very important where the states don't have a concept of the registered mortgage. If you go to the Andhra Pradesh or Tamil Nadu, you are working, or Karnataka, you are working, it is a registered mortgage. You may not have you might not face kind of issue like this, that customer may go to court and tell that I have not created any security interest or intention was given by my side. How bank is going for the SARFAESI? But cases with the states like West Bengal, Bihar, and Kerala or Maharashtra, where the proper registered mortgages are not there, there you face this situation where EMTs is very mandatory for 460, 461 to be taken very mandatory, keep on the records, because that is the agreement which tells that they are ready to create the intent, their intention to create or depositing of the title deeds. and somebody is from the East Syndicate or East Syndicate branches, somebody working, you might be seeing that the ASD 8 and 9 will be there in that, creation of mortgage and this. So those documents are intact, maybe intact with the old document. So don't think that it is not a parcel and parcel of the document, don't throw it in. Keep it till the loan closes. This is very important point. Third important point. Amount claimable from the borrower should not be less than 1 lakh. Okay. If it is should not be less than 1 lakh, this 1 lakh means which balance? Whether it is a book balance or it is the CBS balance, 7026 balance, or you are seeing AC002, there you go and you see the book balance. Which balance is this 1 lakh? Maybe some answers. 7026, I think. What is this 1 lakh? Okay. 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 So most of the people are saying book liability, my dear friends. No, it's not the book liability. It is the total liability, that is 7026, means whatever the unaccrued interest CBS is calculating, we will take that into the consideration and we'll check this 1 lakh is there or not. So very few cases like this will come that it has come to the up to the 1 lakh. Very rare cases, but most of the cases will be more than 1 lakh. And if you have to see the 7026 balance only, as per that balance only, we are going, not the book balance. So when I ask the book balance, I hope the my audience knowing what is the difference between the book liability and what is the 7026 liability. If when you are seeing the NPA balance in 7026, it may show that it is 5 lakhs. But when you really go inside and see the AC002, maybe the 4 lakhs is the unaccounted interest and 1 lakh is the book liability. That book liability means it may be a principal or it may be a principal plus any charges debited to that account, because interest we are not calculating for the accounting purpose. It is just for the showing on the screen, that is for the customer. Even our books of accounting also that don't show this interest. Okay. So this 1 lakh is includes 7026, means total liability we are calculating. There is no concept of book liability in SARFAESI Act. So please remember. So this may be one point of doubt which can be asked in the question. They may put 1 lakh claimable, 1 lakh book liability, claimable 1 lakh total liability. Like that, they may question may be framed. So be careful while answering. Okay, because you see all the points are there. 1 lakh, 1 lakh, 1 lakh is there. All 6 points will be there. But only that 1 lakh they might have changed the book liability. But you have not pointed out or focused on that it is asking. You tell that all the points are correct, how the which, and then you will say the akkad vakkad mambebo and you answer it. Then it will be wrong only. So amount should not be more than 20% of the principal amount interest thereon. One more important criteria for SARFAESI. So we have dealt it should be NPA. We have dealt security interest might have created. We have dealt that it should not be a less than 1 lakh. Minimum 1 lakh balance should be there. And another is 20% of the principal amount. Somebody is speaking. No. Okay. So what exactly the 20% of the principal amount means? You have sanctioned one loan, say for 20 lakhs. Say one mortgage loan. What's 20 lakhs has been sanctioned. It was repaid very well up to 8 years. 9th year it has come. Customer got ill. He could not able to pay. So account got NPA. At the time of account got NPA, okay, my account balance, I am telling total balance, not book liability. It is 3,60,000. Once again, I am telling if amount of 20 lakhs of mortgage loan has been sanctioned, okay, for 10 years. Up to 8 years, it was going fine, very nicely, repayment, everything was fine. On 8th year, customer got ill or customer got the business loss, something, or something, COVID happened, something, situations happened. With that, the account become NPA. And when account become NPA, the liability of the balance was 3,50,000. Okay. So whether in this case, can we go for a SARFAESI or not? That's the main question. So the law says no. Because he has already paid, there is no intention of the repayment. Maybe some problem, maybe other problems as well. So less than when 20% of the principal interest accrual amount, whatever we have, it gone beyond 20% of their whatever they are sanctioned at that time, less than that. So at that case, you cannot go by SARFAESI. So these cases may come in many of the cases. So be sure, being the authorizing officer who is going to be a scale for or any scale for attending on this, Being an authorized officer, please ensure this point that it should be taken care properly. The next very important, because the 2001 it was sorry to 2021 the major amendment has come that security interest must have been registered under CERSAI. Security interest created is one. Second is after creating the security interest and you have forgot to do the CERSAI. And CERSAI Ravi sir also in the classes in KYC he has told how to remember CER, R, Sai, and so many students might be knowing that how to remember the CERSAI full form and all. So this time maybe CERSAI full form they may not ask, but CERSAI is a one agency, government agency, which is maintaining the central records. In that central records, your security interest should be created with security ID. It will create with the security ID. If you are not creating security ID, whatever, whether you have a original document, whether you have created a security interest, with this point, you may not enforce your security through SERPACY if you are not registering CERSAI. And what is the timeline for CERSAI? Previously, it was 30 days. This question may be asked once again. Previously, it was 30 days. Now it is soon after the creating of the security. So anytime you have to, the loan is released, you have to create the CERSAI. Okay, don't delay. Why it is called don't delay? Because it is a risk on the part of the bank. If some other agency or some other entity will create CERSAI, say for reason that person has got some attachment of the court through some other agency or other financial institution, where after attachment, like I told, no, ABJ attachment before judgment they have given our property only. You might not be knowing. And in that attachment, after doing that, court has registered the CERSAI security on that, or any enforcement agencies has registered. Now it is already cleared. In any enforcement agency also, they have to register CERSAI only. Okay. So any security interest which is registered under CERSAI holds the first priority. Means you have given loan today. If you given loan today and tomorrow some agency has created a CERSAI, although you have a original document, although you have created a security interest, your rights will not hold good. The first priority will be the enforcement agency only. Okay. And the second priority will be yours. So please create CERSAI as soon as you are giving the loan. This CERSAI number is very important in your SERPACY Act. Without this, you cannot move in the SERPACY Act. Please make a note of this. Recovery action under SERPACY Act to be initiated in agriculture loans where securities are eligible under SERPACY. SERPACY also tells that we cannot initiate SERPACY against the agricultural lands. And that lands, as per 2003, one judgment, that lands which is cultivated land only. If farmer is cultivating on this, you cannot enforce the CERSAI. But a farmer is having rice mill on that property. A farmer is having a farmhouse in that property. Those properties we can enforce it. Like tea, coffee estates are there where you are giving their lands are enforceable under the law. Okay, please ensure this. So these are the eligibility criteria. I dealt with very specifically. Please, why means because I want to make very focus on this point that why it is important, how it is important, and how it is going to. Okay. Security is exempted for SERPACY Act. I am facing some issue with the screen changing. I'm sorry for this. Security is exempted from the proceeding under the SERPACY Act. Okay. Like I told that there are the conditions where SERPACY Act you have to follow these conditions. Like that, there are some points where you cannot enforce the SERPACY on those securities. Okay. So what are those conditions? So first condition is where goods, money, security given under the Indian contract or a lien is created. Where the lien is created, we cannot force the surface. Okay. Then a goods. Pledge good means like gold, you are pledging gold, no, like those kind of any pledging you have made, you cannot enforce surface on that. Creation of surface interest in any vessel. Vessel, what is vessel? Like many of the coastal who's working in the coastal areas, they might be financing big ships, cruise ships, or the personalized ships, or some boats to the far sea vendors. So in those cases, any merchant shipping company you are providing the loan as the form of a vessel you are giving, those we cannot. So vessel you cannot do. The same as the case as even in case of the aircrafts, there also we cannot interest. That is why so many Jet Airways flight you might be seeing in the airport covered with the turbine and all, but we banks cannot take it. Neither they can sell it. Okay, the reason is that only because vessels, ships, and aircrafts we cannot sail under the Surface Act. Any rights for the unpaid seller as per the Sale of the Goods Act, and any property is not liable to attachment surcharge. Some properties which are not liable. That is why we have to read our LSR very carefully. Lawyers are very intelligent. They want to make their own money, or any of your customer is a very good friend of a lawyer. He will tell that okay, I will give. So don't. That's why it is also tell that don't give LSR directly by way of the customer hand. You please take the customer, you have to take it from the customer side. You have to send to the lawyer, not the customer. Okay. If it is MSME Sulabh, if it is the RH or if it is a branch. So why it is required? Because you have to see in LSR whether the property is enforceable under Surface Act or not. Because that is why in your LSR certificate, if you see the latest amendment also has come, where it is clear cut mentioned that your lawyer has to give the particular certificate on that the property is surfacely enforceable. It has to be. If it is not there, you cannot take it. Okay. So other two parts already I have mentioned. The any securities where you can not exceed by 1 lakh and agricultural land. These two are the conditions where we cannot enforce the security. So I have already discussed what are the eligible part. These are the exempt part. So if you are reading both, question may come: what are exempted of the following? What are eligible of the following? So 4 points from them and 5 points come from here. So you have to find the odd man out. This kind of questions will be applicable from the side of surfacing. Okay, so very beautiful circular has come this year, 421/21, because this type of circular even have not thought the bank has thought in a very specific manner where private banks, what is the sale they will do private banks of one property maximum by 100 days. One property they are selling 100 days. And when you see our situation, we are not able to sell the properties in 2 years also. There are two things. One is laxity, another is the proper guidance or the proper knowledge is not on the field level. So for this, we are facing the issues. So when I'm dealing with the Surface Act, this 421/24 is one of the important circular once again for your examination point of view. In this circular, they have specifically now mentioned that AGM and divisional manager overseeing recovery legal at RO hereafter as nodal officer shall be the authorized officer. Okay. When you read the Surface Act, there is the concept of the authorized officer, or who is authorized officer, who can enforce the security, and who can enforce the security. Scale 4 above only are the authorized officers who can enforce the security. Previously, what used to happen that any scale 4 who become a scale 4 and gone to branch also, from RO side, they used to designate as them as the authorized officer and the respective. Suppose a branch is in a remote area. Okay, nearby one scale 4 branch is there. So they used to designate the branches of the scale 4 officer of that nearest branch. Officer will be the authorized officer that branch. So whatever the surface related that branch will come, this officer will sign and they will go. So because of this, lot of dependency has come, lot of delay happened, and a lot of the field level experience is less, and lot of field level cases happened where the bank has lost their essays against the surfaces because properly it was not properly documented, neither it has properly implemented. So those cases when came to the picture, the bank has come to the circular and they have told that from the RO side, AGM RO, and divisional manager overseeing recovery will be the authorized officer. He will take responsible for the initiating, monitoring, follow-up of the surface till auction of the sale of the secured assets. Okay. Now, these points you keep on noting. Anyhow, I'll share this slide to all, plus for your side, for remembering, keep on noting. They have given the enumerated steps, 4-5 steps. Tanujji, please do not keep on annotating on the screen. Okay. There's a timeline has been given very specifically. In what timeline it has to be done? Aniksha, do not mark on the screen, please. So step 1, timeline 0 to 3 days. Okay. What is 0 to 3 days? 0 to 3 days of NPA. So NPA, today is the NPA date. So today is the 0 date. So 1, 2, 3. In this 3 days, demand notice has to be issued. So Surface Acts, I will also specifically tell the limits in the Surface slides. I have not mentioned much of the writings. I will be speaking on my behalf. So you keep a note of the point of those things, or the recordings are available. It will be better and helpful to you. And I will speak more, and the screens will be having less of the data. Only screens to you understand the step 1 procedure is issuing of the demand notice. So when demand notice issued, 0 to 3 days. Now it has been very specifically stated that you should not go beyond. And last time this was a question for 4 to 5. Last time it was a question of for the 4 to 5. 1 minute.
आप उठ गए बॉल ले चलो आगे
Disila ji, I think video is off again for my video. It's not started because you have stopped.
Wait, sir. I'll check it out. Check now, sir.
Thank you. Yes, 0 to 3 days. Somebody is writing V Rakhi means 4 days. That is inclusive of NPA. Yes, yes. It is inclusive of NPA. So today's NPA is 0, 1, 2, 3. Means within 3 days, it has to be ensured that you are issuing. Your means your authorizing officer from RO is issuing the demand notice. Okay. When we are issuing the demand notice, RO may insist you format so that insist you the format to give the details of the account. So what is the balance? What is the securities available? Also, it is a duty of the authorizing officer to go and check that what are the documents details available in the branch. Like documents are in the proper or not, whether we are getting a proper documentation has been done or not, whether CERSA is created or not, if CERSA is created, whether the EMT is maintained or not. These all things, whether then after that they have to go and check the property, whether property is intact or not, whether it is a land or building. To identify the property is a very important part. So these are the parts they will do. But 13-2 issuance to happen in 0 to 3 days. One of the important questions once again. And last year it was asked in 4 to 5 also. Within how many days? Within how many days the surface to be initiated? That is G2, 0 to 3. So when surface initiated 13.2, what is this 13.2? What is this 13.2? Krishna is telling you to go to the edit option, but I am not getting edit option in annotation. I'm not getting. So 13.2 is what the 13.2 is given. No problem. Anyhow, I'll just take it stock of this. No issue. So when I'm talking about the 13.2, why this 13.2 is called demand notice? This 13.2 is, and this annexure one which I mentioned is as per the 421 that circular. This is the annexure format. Henceforth, you have to use for using the demand notice. You means if you are authorized officer of the RO, going to be authorized officer at RO, or already anybody is there at RO, they have to use it. Moreover, 13.2 means it is under section 13.2 of Surface Act. That is why this is called. So demand notice has been defined under section 13(2) of Surface Act. Usually when you go to court, somebody is having the experience of going to the court, there nearby bookstall, you go and you can purchase. Very small book will come, very some few pages only. It will be hardly it will be a 50 pages. It will called as a Bare Act, BARE. You can note it down. If you want to more know on the surface, you want to be a very prudent banker on the recovery side, so please purchase this book, Bare Act, very useful, and take the latest edition only. Okay. Bare Act it is called under Surface. Bare Act, they have many topics. Bare Act limitation, Bare Act survey. So Bare Act, you take Surface only. There will be a very useful books these are. So where you can usually learn about the Surface, what to happen. So 0 to 3 days is the timelines of the bank. It is not told in any act. Okay. So what I am here, I want to merge with the two concepts: what bank is saying, what law is saying, and how on the practical we are going to do. These three things are the very important, which I am going to tell you. So 0 to 3 days concept for your examination. Demand notice is under section 2. To know about the section 2, that is under section 2, demand notice defined. What is demand notice and what it contains? So demand notice, as per the notice itself, if you can see, the demand notice says that it is the demand to the borrower or a kind of a recall to the borrower that this amount got NPA, please give back that money and give back that money. And whom to send this demand notice? Whom to send this demand notice? First is borrower. Second is guarantor, co-obligant, or mortgager. So what I mean to say is demand notice to be given all the stakeholders in the sense, in your agreement, 5 people are there, mother, father, son, daughter, are there. So all should be given with the notice. Don't be so miser in the branch. We are already wasting so much of paper. So on this part, at least don't think that I will save the paper by putting one paper, all the name in one paper and giving in one address. Don't do it. Let 5 demand notice in 5 names, 5 envelopes to send in one address only. No problem. Okay. But do it. Do not leave it. Okay. So all the stakeholders has to be sent. Then another if suppose whom you are going to send the notice, you got to know that he is or she is already expired or demised. So what the condition says, if the demand notice has to be served, if the person who you are going to serve the notice is expired or demised, you have to serve the demand notice to the legal hire. It is a very great headache job. Please ensure you have to ensure who is the legal hire. You have to ensure where they are living. If suppose where they are not living also, at least you have to ensure who are the legal heirs. This is very important. So you have to take the service of the local revenue departments and all. So that is one part you have to do. So in this case, this 0 to 3 day norms may differ. So case to case it may differ, but 0 to 3 days you have to initiate. And in this case, where the case of expiry is there and all, you have to be very careful. Okay. So do not issue the demand draft on the safe or name of the same sake, because after this cumbersome job of say 90 days you are doing, at the time of the sale, if somebody comes and go to knock the door of DRT will straight away cancel your process. Okay, so there are the repercussions to this process. This process is powerful tool, but I told that with power comes responsibility. You have to do with the responsibilities. And on the practical ground part, when who's ever doing surface, please maintain separate file. If you're maintaining a separate file in RO, well and fine. If you're at the branch level also, I insist that RO, although might be maintaining separate branch level, in the document itself, you make a separate folder and keep it surface, demand notice, pin it. Then when it was sent, the postal receipt, pin it or paste it on the notice. Okay, so keep it. And when we are sending this demand notice, ensure that all the notice are sending with acknowledgement with due. You have to send the notice with AD. Okay, without AD, demand notice should not be served. Okay, and it can be served in other modes also. Like you have sent the demand notice in the 0 to 2 days or 3 days. Notice has gone and party has denied to accept. Okay, or party is not available on that address. So those cases, banks, to be on the more prudent side, bank can serve this demand notice by pasting this demand notice. 421/24 says that you can paste the demand notice on the property, on the house where they are staying, and you take a video recording of that notice and do it. And another part also we are doing on the side of demand notice is paper publication. Okay, you have to publish the demand notice in the paper publication. We have to do for the demand notice. Okay. What is the step 2 is telling? That is on 4th day to 10th days, serving of demand notice has to be finished to the guarantor. I told now, to the guarantor, to the borrowers, to the mortgager, to the stakeholders, whoever it may be. Okay. And demand notice in case of what I can say, the demand notice in case of consortium accounts also bank can issue. Only when it comes to the position notice, I will deal with that. Then the 60% consent has to come. Otherwise, demand notice in case of consortium accounts also we can do it. Okay, and within 7 days, you ensure that the demand notice, whatever you have issued, it has reached the borrower, it has come to you, and you have received the acknowledgement. And acknowledgement sometimes it happens that acknowledgement card might not have received to you. So ensure in that case, you see the postal delivery online. If it is delivered, well and fine, take that copy. And also with that copy, request the postmaster of the department that we have sent this notice. Acknowledgement receipts has not come. Kindly give a certificate. He will give one certificate that it has been acknowledged by this and with report of their report, their whatever the register they are taking and signing. No, that copy will be given. Why I am telling this is, if demand notice is served, acknowledgement is not on the record, or you have not properly taken care of to keep that acknowledgements on the record, so it may be a situation will happen when you reach up to the level of sale, your sales will be stopped by the borrower by giving a one clear to DIT that the surface action is wrong. They have not followed. Okay. And any borrower, while giving demand notice, you see that they will not come to you within that 60 days. Okay, demand notice while we are giving, where we are making a demand, we are giving a time slot of 60 days to him or her to pay back this amount or to revive this account. But if it is not happening, then we'll go to the second step. Okay, so just now I told in the third step, what is telling in the 11th, you have taken care of 4 to 7, the demand notice is served. You have gone for a checking acknowledgement, not has come, it is not properly gone. Then we can go and we can serve the demand notice. Okay, on the fixing the demand notice on the paper, ensure mandatory paper publication, and exemption for the paper publication can be given by circle head only. This is one of the important part of your question once again. So maybe asked that it may be asked that in what case the exemptions can be given and who has the power to give the exemption in case of surface C demand notice publication not to be done. That or any surface action has to be stopped. In that case also circle head is only the power to stop any action in surface. You cannot stop your own. Okay, because we have not received acknowledgement, we'll stop it. Or some party has come for OTS to me after giving the demand notice, I will stop it. No. Just now in the morning only the first slide I showed, no, stop not till the goal is reached. That's all. That is the case. You have to ensure that till the recovery, till the upgradation, the things to be moving on and on and on. Okay, you cannot stop it. Just now only I told in respect of the consortium account, bank can issue the demand notice. Consortium means where 2, 3 banks are there. So in those cases, banks can issue the notice. Like consortium, Canara Bank is also there, SBI is also there, and Union Bank is also there. So Canara Bank respective demand notice will go, SBI respective demand notice will be go, and the Union Bank and demand notice goes. Maybe SBI is a lead bank, but it is delaying to send. But we can send the demand notice. Our demand notice we can send. But when it comes for the 13.4, that is the position notice, and for validity with the position notice, in that case only the 60% consensus is mandatory that they have to give in. Okay, this one. So please ensure that this 60% which I am highlighting. So these are the examination points. So in case of consortium account, 13.4 for the issuing 13.4, that percentage of consensus is required. So it is a 60% which is required. So if it is a borrower of the corporate body, I told it is a company or the private firm or the partnership firm. So demand notice should be served on the registered office. Okay. One more doubt on the practical ground you might be facing that The loan was given or 5 years back. Registered office is XYZ at Mumbai. But now registered office is changed to YZA Mumbai. Pin code is changed. But what you have address is the same address. Whether we can serve on the address? Yes, we can. You can serve your demand notice as per registered address given in your agreement. You can do it. If it is returned back of the some cause and all, we know the second recourse what we have to do. That paper publication and all it can be done. And I already told that if it's a deceased borrowers, please ensure demand notice should be sent to legal hire. Okay. So don't we can send them and nothing will be there written there and disease has come. It will be again a problem for us in the when we go. Why I am telling problem because till the surface reaches even surface completes says you have sold the property there is 100% chance that borrower again today borrower is not having money you have sold his house is 1 crore house, we have sold it 80 lakhs. Because 1 crore for him, but for us, our value as well, it is 80 lakhs only. But after say 5 years or 4 years, he will receive hefty of money. But he has this in mind. The bank has sold. He will challenge your certification. Essay will be filed in the tribunal that they have done wrong. Okay. So in that case, the court will ask all the documents. Where are the things? Okay. As per your record keeping again, you have to keep all this record of the 5 years and all. Okay. 5 years, 10 years as per the keeping policies. You have to retrieve all these documents and you have to go to the court. Yes, we have done it correct. That is why on the practical side, wherever you are selling the properties, surface properties to the borrower, any borrower, please ensure that copy of that all the proceedings of the surfacey to keep on record and that document. Suppose borrower A, you have sold the property, okay, of borrower B. Borrower B is a defaulter and you have sold the property to the borrower A. So borrower B, what are the proceedings you have made for the surfacey to sell his property? These all copies should be there available in the borrower A documents so that in future if a challenges comes, we have to address the challenges. So we can do the delivery of the 13/4. We can register post speed, post courier, fax message, but acknowledgement is must. But when you are doing fax and electronic mail services message, when you are doing a confirmatory copy should be sent to the registered post. It has to be done. When you are sending mail or fax also, a registered post has to be gone to that. Okay. Now coming to step 4. Borrowers will be very clever. Okay, they will definitely put some hurdles and try to put some hurdles to you to go for this surfacey. 60 days time we are giving on the demand notice. We are giving 60 days of time, saying that within 60 days, if you are not paying, we will go for a 13/4 and we will go for a seizing your property. Okay, this is what our stand will be in the surfacey. But law has given one more opportunity to the borrower that in this demand period, if borrower gives the representation, okay, if the borrower gives the representation or we have received any representation, in that representation, you have to be very careful. Again, once again, if borrower is giving any representation in the period of demand, you have to reply that representation within 15 days. The timeline which I am telling within from the date of receiving representation is a timeline. That 15 days is the reply. Your reply has to go within the 15 days from the receiving representation. Suppose say today we have received the representation. So you have to send this representation to your authorizing officer. He will revive it. He will review it. He will check. Then he will draft one reply and he has to send that reply in within 15 days. Those reply copy those letter when they have sent the copy of the docket numbers and all postal docket numbers has to be preserved. Why? Because any borrower has raised this kind of representation means he is having very well of intention that on this point he can stop the surfacey. Because in the court cases of Kolkata, one of the State Bank case only I'm telling, where bank has so gone to up to the selling of the property level. On the D day, he went to DIT. He told, "Sir, surface is wrong. Why? Because I have given this representation and the demand period. They have not given any reply to me." Straight away, DIT has cancelled the surface. It means the work of 100 days is gone. Again, he is very happy because he will get 100 days of time. By the time again transfer season come and who was doing that person, he will go file we are having some problem, file no missings will be there, not proper documentation happened, and he knows it, and he will get a more 100 days or 150 days of time, and he can live happily in that home, taking the money from us and enjoying the facility without paying a single penny to the bank. So please do not let it happen. So one small example, right? He can tell, sir, as per your demand notice reference number such and such, Mr. De Silva, I would like to tell you that you are very much handsome. Thank you. He will write and left it. The demand notice where De Silva has issued. De Silva, you are listening now?
Yes, sir. Very much. Thank you,
So,
sir.
yeah. So this Silva will be getting one letter as the authorizing officer. Sir, as per your demand notice reference such and such date and date received by me on such and such, I would like to tell you that you are very much handsome. Thank you. And he will leave the reply and leave it. So whether those has to be replied, those letters has to be replied, yes or no? Your chat can say yes or no. The Ashish Bazwa says yes. Okay. This kind of silly representation he is giving, that you are very handsome without any giving any other. Deepak Jha say yes. Sangeet say no. Navi say yes. Okay. My dear friends, whatever may be the silly representation, you have to reply. So this will has to reply that answer, stating that, uh, sir, thank you very much for your appreciation, but we will not stop till you have given the full amount, and you have not paid the full amount. The proceedings will not be stopped. And that reply has to replied within 15 days. Again, once again, I'm repeating, it is replied in 15 days, not to reach in 15 days. Within 15 days, replies must please keep the reply. Also, the post dockets can be given where we have to preserve it. That representation has been addressed properly. This has to be there. Okay. This is a very important point in the SARFAESI Act, where the demand is issued within 60 days. Somebody in the reply, I'm seeing that they are asking that the demand 60 plus 15, it is not like that. Within 16 days of the time frame, he can make his representation anytime. He may be doing that on 60th day also, but our reply has to go 15 days. There is no stoppage, no change in the timeline. Once again, somebody has told that, sir, 60 days is there, and 15 days again we will give, that is 75 days. No, not at all. You might have raised the representation on 60th day. You might have received on 60th day, but your demand period is over. You replied within 15 days, no problem. But the next process will be start continuing. Means we will go for a again 13-4. Okay. And this is on the theoretical side, but practical side, anytime you are getting representation, even your representation you might be getting at the time of 13-4 also, please try to address it. This is one point where DRTs will go by law also, but sometimes I am seeing the DRT executions where the DRTs judges are sitting. They sometimes very much practically they will give the judgment. Okay. And such cases which I have attended in the judgments where we were supposed to lose the SARFAESI, and judge was so angry that he was telling that he may be reversing our SARFAESI action. So each and every point in the SARFAESI is very important. So that you have to make a very important note of this. Okay, so within 15 days, reply is must. It has to be replied within 15 days, not the reaching time. Once again, replied will be done. So our part is over. So whatever we are discussing now, the reply we have to be given within the 15 days of the receipt without any fail. Okay. Okay. What will happen if the 60 days time is over? What that can take? So bank has the following recourses to do, that we can go for a taking the position of secured assets. We can take over the management of the business. We can appoint any person to manage the secured assets and position. Like some hotel, you have given the say demand. Whether we can vacate in one day and we can take the position, no. In those cases, we will try to take over management. Some hospital, we have given the demand. So hospital, we cannot to go for a SARFAESI again and again. So there, in that case, we try to go for a management, taking over the management. Okay. So, or we can appoint any person, some resolution. So this is a concept somewhat near to IBC also. IBC, where we have a resolutionary practitioner who is going to be appointed from the creditors to look after the business. And why this concept is there, Why? Because if any unit is running, any manufacturing unit or any other unit is running, when it is in a running condition, you can get the good amount out of it. Suppose you have seized one manufacturing unit, say a lot of machineries and all. You after seizing, you are not finding the proper bore works, and it becomes 6 months, 8 months, 1 year. After 1 year, the machinery values or machineries might not be working properly. It may be chances will be there. So in that cases, the value of assets is decreasing. So in keeping that into the condition, this concept has come that in 13.4, you can go for a takeover of management. If this person is not able to manage, another person who is interested or who is of the existing business having four, he want to make one more unit, he can take over that with, again, as per the law. It is not that we can go and change it as per our will. No, as per the law. So these are the recourses available. Then comes our step 5. That step 5 from the 65 days to 85 days. Now, I told that it is a 60 days of time over. Okay. So 60 days of the time over, once again, 60 days from what? 60 days from the issuance of the demand. 60 days from the receipt of the demand. 60 days from the paper of publication. So 60 days from the of the demand. Okay, person should acknowledge. Suppose you have sending a demand notice with your with you and your SKP has gone and you have taken on the register. So 60 days from that starts from that date, from the issuance of the demand. Case 1. Case 2, you have sent the registered post. Registered post reached after 2 days or 3 days. That 60 days from that 3 days, after 3 days it will start. I told that within the 4 to 7 days, you have to retrieve and you have to check whether it has been rejected, but they have not received it or they have rejected that they will not receive this notice. You have given paper publication, then the 60 days will be over from the paper publications. Okay, so remember the 60 days. So bank very judiciously has given the timeline from 65 days, not from the 61 day he has not mentioned. They know that maybe a delay in the postal or delay in the this may happen, but 5 days the cushion period they have given. Okay, so on 65th day to 85th day, what we have to do is we have to start the process of taking a symbolic position first. So again, once again, what is symbolic position? That is, we call it as a under 13.4. We call it as a 13.4. Okay. So 13.4 is the case where, again, 13.4 means it is a section 13.4 of SARFAESI Act where you are going to take the symbolic position. Means we have to go, we have to paste a notice on the wall, we have to take the photo of the notice, we have to take the photo of the house. Your borrower is there, means well and fine. If it is not there also, authorizing officer standing and he is taking the photo. And we have to keep on the record all these proceedings. Okay. And when position notice, the PN what I mentioned here is the position notice only, the symbolic position or it can be a physical position. So usually first we take for a symbolic position. It can be a land or it can be a house. So house means we are pasting on the wall. Suppose it is a land means what we'll take means we'll make one placard. There we paste the notice. We will put that placard on the ground and with the placard we take the photo. Okay. So that is what is required. So position notice which we have issued or we have pasted, it has to go postal once again. You have pasted today on the wall. Today itself you send in a post. Second, within 7 days of time, you have to publish this notice in paper in 2 leading newspaper and one should be in the vernacular. Vernacular means local language. One is in English, definitely. Another is the one, if it is Tamil Nadu, in Tamil. If it is in West Bengal, it is in Bengali. If it is in Andhra, it is in Telugu. So you have to publish the position notice in newspaper within 7 days of your position notice. Once again, if you are not doing this paper publication within 7 days, my dear friend, you have to again repeat this procedure. There is no way. If you missed this paper publication within 7 days, you have made on a 8th day. That means SARFAESI is already going wrong. You have to again paste a notice with a different date. Again, you have to publish in notice. But whatever process you have done for publishing notice, the money you have given, it is wasted. Demand notice given, 60 days time is over. If any representation, you are representing in within 15 days. Once 60 days time is over, bank itself has given a cushion of 5 days of time. After 65th day onwards, you have to give the position notice, checking that demand acknowledgement has been made. If acknowledgement not has come, means paper publication is there. With that, you have to go for a second process, 60 to 85 days, position notice is given. Okay. So when position notice is given, you have pasted means it does not your work is over. Here onwards, your cubism work will start. How it will start? Take the valuation of the securities first. Anyhow, you have identified the security. Identification of security should happen in the demand notice time itself. Then once you have given the position notice, go for a valuation of securities simultaneously. Why? Because we have to sell the property means we have to ascertain the valuation. It may happen that you have taken the valuation 3 years before. As per our policy says, no, 3 years valuation is enough. So your account become NP on the second and half year, 2.5 years. That same valuation will not work once again. Because that valuation what we have taken is a valuation, normal valuation. For doing SURFACE, SURFACE approved valuer has to give the valuation. It may be possible that the valuer who has given that time valuation, he is also a SURFACE unpaneled valuer, but SURFACE valuation separately has to be assessed by the SURFACE valuer only, and that valuation specifically mentions about that SURFACE valuation. Okay, so SURFACE valuation has to be taken as per the extent guidelines. Enters the Caesar agent and advocate for filing under Section 14 of SURFACE Act before DM, CM, and CGM, praying assistant for obtaining physical and actual position. This is the condition to condition, it varies. In some cases, borrower, the cooperating borrowers, they tell that, okay, sir, anyhow, I lost my job and money, I cannot do anything. You can take the keys and you can do it. So it is an easy case, very simple case, over. Okay. So in those cases also, we used to take one letter from the borrower. Yes, I am fine with it. I don't have any objection. You do it and it, then okay, over. Okay. But cases will be there. Most of the cases will be there where person will not allow to take the position of the physical position of the house. Why? Definitely, most of the emotions are related to the house. It is maybe the income generating unit for him, maybe a commercial complex giving the rents. All these things will be there. So definitely nobody will let know very easily to take the position of those properties. Okay. So in those cases, what will happen? We have to go for a filing the PI in the CGM or CMM or DM under Section 14 to take the physical position where SURFACE executor like notary will be allocated from the court side, who will be executing the SURFACE while doing that physical positioning. He will be being with us for the Panchanama, and we will also get the police assistance wherever it is required. We will take the police assistant to clear up the physical positioning. So under Section 14 of the SURFACE, we are doing. So this is one of the important section. You can make a note down it once again that under Section 14, it has been written. So Section 14, they usually ask DMM and CMM filing will be done under which section of SURFACE Act, because 13.2, 13.4 many people will be knowing. But whether it is Section 14, what they are doing, they might not be knowing. So they may ask this question. So 14 under Section 14, the SURFACE Act says that file the CM order. And here also on the practical ground, nowadays banking, we are not no more going for the DM or DM orders. We are mostly going for the CGM orders. Okay, why this change has come? DM, who is DM? DM is the district magistrate and CGM is chief judicial magistrate. Okay, so instead of taking the orders from the district collector office, we are trying to take from the court offices. Okay. The practical reason on the ground is when it is going to the DM offices, is getting delayed for unwanted reason. And most of the, like if suppose parties are very politically very influential person, it's very difficult to get the DM orders. Although law says the 30 days time will be given, within 30 days the query has to be raised if anything is there and has to be given. It can be maximum extend to 60 days as per Section 14. These 2 points, it is not in your slides. Make a note of it if you're noting down. Under Section 14, we are making the plea in the court to take the physical position by appointing an attorney from the court side and also taking the police intervention. The 30 days time is there. They have to give this judgment within 30 days. If the 30 days is not happening, maximum by 60 days, they have to dispose it off. Okay. So this was not happening in the DM level office also. So most of the bankers on the practical side, we are more to see. CG. So we are taking the CG models. Okay, when we are doing the physical position, you got the order. Okay, attorney will be allocated from the court side. He will say that he will go to the borrower, he will give the notice, he will tell that on such and such date we will come, we will seize your house. You please give the peaceful position to us. If you are not able to give the peaceful position, we may have to call the police and we may have to take a police station to vacate your house. And on the D day, when the seizure will start, okay, you have to ensure this following: the recording of the video, entire position is very important part, because whatever we are doing as per law, again I told, with powers becomes responsibility. It is our responsibility. We have to ensure that we have to keep on the record. We have to take a video recording of the positioning. Okay, we have to maintain the keys. We have to maintain the panchanama, in which room, how many lights, how many items, what are, because our customer may tell that at room kept my gold. People have seized after that somebody has come and taken. So all these things you have to avoid. So those cases we have to ensure that this is happening on your side. Okay. So when we are taking the physical position, this is on the practical one. Once again, I would like to share my own experience. When we are taking the physical position, be very careful. Do not indulge into the fights or the arguments or the snatching, sneezing, snatching on the things and making any unparliamentary words using. No, no, not at all. Simple thing has to be done. You have to figure out if party is resisting, use the police force to take care. You should not even touch the party. Okay. So the cases will happen that sometimes in one of my own surfacing cases, what happened? The party previously, he was telling, okay, sir, I will give you very much polite. Yes, sir, we will make it. We'll do it. The day when we went, morning 7 o'clock itself, party is not there home. Who is there at home? Only his wife and daughter. So you got the intention. So if you are entering in the house, if you are doing something, he will putting some other case on us. So what to do then? Then the police has been called, lady police has been called, then they have helped us to take it out. Because all this, whatever we are going to do, it is recording. Okay. Any harsh words or any mishappening or any fights and everything seen on the video recording, the court itself will cancel this process that it is not here, because we are not the keepers of law and orders. We cannot take law in hand. Okay, so for that only we have to take the police decisions, and wherever this kind of situations will happen, we have to vacate the house and as soon as possible, because time is not there. That person who was not there at home, he actually went to DRT to cancel this order and to make the stay on this order. He was trying for that. So when we came to know the staying order, we started locking the rooms. There were almost 8 rooms, first floor, second floor. So all the rooms of first floor been locked, all locked. Then main room, that lady was sitting. That she is telling that I will not go from home. Police has been called. Then lady police has come. They have taken hit her out, and at last, finally, we could lock the main door, and he came with the order of a stay. When he came with the stay, that by that time we have already locked the door. So we told that it is locked. The stay has not. He told that to open it. We told that no, it is not possible. It is already locked, and we have to be very firm in these cases. Okay, your authorizing officer, the agents, the police, everybody to be intact. He told that no, it cannot be possible. The stay doesn't hold now because we already locked. Before locking would have been come the stay, and what we have locked is the main door. There was only veranda was left. So we told that this veranda we are not locking because you got the stay, so veranda is yours. But door up to door you cannot touch. So at anyhow, we could able to complete the position. So taking position, you have to be very vigilant. You have to go early in the morning. You have to take the police assistance and ensure that police and everything. Where this kind of forceful situations comes, you have to be very careful, and we have to do this position very carefully. And once the position is over, please popularize the property, that the property which we are going to sell. Also, put the banners on the property. This property belongs to this under position of the Canara Bank, like that. Okay, and security is taken in the physical position to be provided security. And one more case. In this case only, I am telling. Everything was over. It was a very cumbersome day for us. We left to branch. Then I kept the seized keys, the panchanama, and the vault. Everything is over. We closed the vault by 8 o'clock, like that. And I was going to home. There was a suddenly call from my attendant. He told, sir, that house light is down and somebody is inside. Which house? The house which we have seized. I said, how it is possible? Then I called, that time I was the only scale two. Then I called RO authorizing officer. I said, sir, the attender is complaining. Then RO, he told that, okay, you go to that place, we are coming. And when we came, we seen that this person has broken the keys and entered into the house. So it was a very critical scenario and all. There we have again the night, it almost 8 o'clock, 9 o'clock it happened, where we 10:30 was the time. We told that if you are not vacating this, we have to calling the police and we have to file a criminal case. There is no other. And please, friends, when we are doing surface C, when we are taking possession, once your position is taken, it is our property. It is our property. Yes, it is our property. Once again, I am telling it is the Canara Bank's property. It is not a borrower's property. Borrower once pays freeze from the all the dues, then only it belongs to borrower. But till that, it is our property. Please ensure, and the time of you have to be very firm, and your knowledge only going to play on the ground. That time that property was shouting, it is my property, go out. We told that, no, no way, it is not your property, don't tell. It is our property. It may be your property one time, but you are given to the bank, it is our property, you have to vacate. So when you are also taking the physical position, the another duty as a operating officer is to take care of the property. Property should not be gone for theft and all. In case of one Indian Allahabad bank case in Odisha, it was Katak, I think. Possession was taken of the house. Very well, everything is fine. Very much, everybody is happy. Next day morning, news came. The house has been demolished. By night, one bulldozer has been driven and house has been. That party was so arrogant that you have taken my property. Okay, you sell it now. He has he has demolished that property. That is what the condition. Okay, so this kind of things can happen when the surface is not dealt properly. You have to keep the security agents ready, security to be given to the properties till the disposal of the properties. This all has to be taken care in this step only. Nodal officer to file caveat, and caveat is one of the filing which you have to do at the time of the positioning only. What is caveat is? Caveat is just clear to the DRT that if party approaches you for the stay order, please intimate us and give the verdict. So that time also that we have given the plea only, then that time only we came to know that party has approached to DRT to go for a stay. That is how we came to know, because we filed the caveat on those cases. Okay. So this case it has to be very important. And doubtful and lost case is one of the point and examination point of view. That is why this point I have noted on, where the doubtful and lost cases are there. In doubtful and loss cases only, more, which is the liability is exceeding 50 lakhs, authorized officer may use the service of resolution agent empaneled with the banking. So resolution agent more than 50 lakhs in doubtful loss cases, we can take care. That is just for examination purpose data, nothing else. And I told that we have to put the banner on the property. So what banner should write? This is the write-up position of the cameraman. Trespassers will be prosecuted by authorizing. That is what, because once you have taken the position, it is your property. Now somebody is intruding means it is the criminal case. Okay, maybe he is the borrower. He is telling it is my house, but it is a criminal case. So this should not happen. Okay. In surface, one more segment may come that it may happen that wherever the properties you have, there may be a tenants. If tenants are there, whether we can go for surface or not, there are some three categories which our policy is describes that how tenancy will be dealt with. If tenants are there, so Harshvardhan Govardhan, this is the one an international asset reconstruction case where Honorable Supreme Court has classified into three categories and given the judgment in that way that how to do this. Okay, so there is a category one where tenancy agreement is there prior to mortgage. So you have suppose given a one mortgage loan, okay, today, but your valuation report, the value also maintained, and while visiting, you have seen that there are tenants available in that property. So tenancy agreement is there and tenants also there in that property. In those cases, tenancy agreement is binding, evicted only by moving civil code. What does it mean is, if you have initiated surfacing, anyhow, you have to vacate that physical position, we have to vacate the house, both tenant and owners. But if the tenancy already existing at the time of our mortgage, so in that case, you have to ensure that this case may come under this, and you have to ensure that tenancy, whatever the agreement they have taken, if it is coming into the picture, and tenancy, if you while giving 13.4, we also give the notice to tenant to vacate. But if it is backfiring, or he is telling that no, I want to continue, I cannot leave it, then at that time we cannot go to DRT. There at that time we have to go for a civil court movement, and we have to clear it off. Next condition will come. What is the next condition? That is after mortgage, but prior to 32. What may be the condition to us? That after mortgage and prior to this. So what will the condition will be coming? So after mortgage, but prior to 32 means demand notice we have given. At the time of mortgage, there is no tenancy. But after mortgage, before giving tenancy, means maybe after 1 year he has taken, and after another 1 year it become NPA. So after mortgage, he has been a tenant, but before giving our demand notice itself, he is a tenant. So in those cases, we can evict it by the CM. I just told you under section 14, we file the CM orders and CJM orders. In that order itself, we can evict the tenants. And the third case, the state of a case where tenancy is there, and after the 13.2 issuance, we have issued 13.2. After that, the party is telling, no, my house is having tenants, or just for the litigation purpose. So it is a intention that the tenancy is going on. It is very evident that it is intentionally is done. So there we can evict by CM order. But once again, what will our condition? Suppose this tenancy is coming, what we will do? These three conditions I have told. One is the tenancy before mortgage, tenancy after mortgage before 32, and tenancy after 32. So 13.2 after and after mortgage cases is very clear cut. In same order we can clear. But tenancy before mortgage, it is there. Then in those cases, as per the section this 17.4A in SARFAESI Act, this was the amendment given in 2016, implemented later on in 2021, where DRTs are empowered to decide on the issues related to tenancy. Now, courts and judicial forums previously. Yes, ma'am. Courts and courts, where I told that it has to be go to the court. After coming this amendment, now we can deal in the DRT itself. If tenant has to come, he has to stop the and it is very rare case, because wherever the mortgages we are doing in corporate, suppose wherever the property we have mortgage, maybe one corporate office of TCS is there. Okay. They cannot vacate their office and all. No, so suddenly you will tell that no, you vacate this office. So those cases, what they will do, to stop that order, they may approach to the DRT to stop the. And the second part, when this is happening, I already told that we can take over the management. We can take over the physical position, or we can take over the management when the 13.2, when 16 days demand notice. After that, I slide already told you that when the 16 days demand time is there, what bank can have a recourses. So those cases, what we can tell, we have to direct them to credit the rent to our loan account. Okay. So this is the one of the case which we can do in the SARFAESI, where the tenanted properties are there and a good amount of tenants are there. We have to give the notice to them that we have to create the rent to us, with the receipt will be given by the bank. Receipt means our own deposit slip. We have in the form of a receipt we give them, so they can deposit the rent, the monthly wise. And it can be, and we have to maintain the register in these cases, like which month they have paid, and tomorrow dispute should not come for those cases. Though like that, we have to maintain. Now coming to step 6, we have done the physical position. We have taken the properties lock, properties under security. We are doing very well. Paper publications and all is properly over. Then we have contacted the good number of parties for the sale and all. Now coming to the part of the ensuring fixed prices. Though what I am telling this part, it is simultaneously happening. 65 to 85 days is my positioning time. So in the positioning, I am taking all this, whatever I spoke right now, it is simultaneously happening. Then on 81st day, what is coming into the picture is we have to fix the reserve price for the mortgage properties within 3 working days of the taking position. So taking position was happened at 65th day, means as per timeline, on 68, on 69th day, our reserve price fixation should be over. So I already told in 13.4 that valuation to be taken. So when valuation to be taken, what will happen? Then valuation taken for what we are taking valuation for fixing this reserve price. That what is the reserve price will be. So next condition, when fixing the reserve price, what can be the my conditions? So when I'm fixing the reserve price, there can be the condition in a two way. One is GLR is more than RV. What is GLR and RV is RV is the realizable value of the property and GLR is government land rate. So it is the GLR we are telling. So government decides and it differs from state to state and the state revenue departments, they give this rate. So GLR is more than RV and second case may come that GRL is less than RV. Kindly mute your mics. GLR more than R. Okay, when GLR is more than RV, there can be two conditions come into the picture. Where if GLR is more than the realizable value, in that case, reserve price fixation to be done at or above the GLR only. Means if this is higher value, it is very simple condition. See, if GLR is more, then definitely we have to go for a GLR only. We cannot do less than GLR. And it can be fixed RO head CAC. This may be the one question that who is the fixation authority. In the next slides also I will tell you which who is going to give the fixation and what level of the reduction of the prices will be allowed by whom. But that is one of the slide where the last year also question has been asked. So this also expected questions will be there. So while putting the reserve for a price to be fixed, if it is a GLR is more than RV, then GLR minimum GLR price on GLR price or above the GLR price only, we have to fix the reserve price for the selling. Okay. Suppose while fixing GLR, auction happened, but auction failed. In the failure condition, what will happen? The reserve price or at or above the reasonable value of the security with the subsequent reservation, the subsequent reduction has to be done. And this subsequent reduction, how to make that I will give in the next slide. That what is the percentage we can reduce and how we are going to reduce. Okay. So when GLR is more, condition is we have to go for a GLR value and we have to go for a sale. If it is failed, then we have to go by the at or above the realizable value of the property. But this is the very rare condition where government land rate will come more than our market rate. Most of the condition will fall on this. Okay, this condition will fall on. So most condition will be falling on this condition. So this condition will be where GLR is less than realizable value. So realizable value is most of the condition when it is saying the GLR will be the less than the less. So when those cases, what we'll do? Okay. If GLR is less than the realizable value, okay, who will be the sanctioning authority and who is the RP fixing authority? If loan sanctioned by branches, various authorities up to RO head CAC, means including Sulabh, including our RH, including branches, whoever is sanctioning, if anything goes on the NPA, who is going to reserve prices? RO head CAC only going to give the clearance. Okay, RO head are going to give the reserve price for the first instance, means first sale they are going to be given. For branches coming under Directive Circle Office, DGM, GM and CGM COCSC. Loans advances sanctioned by CAC of Circle. If Circle CAC is sanctioning, DGM and Circle CAC, COCSC can do. But loans advance sanctioned by CAC at head office level, then CGM, GM, HO, CAC will permit the reserve price, fixing of the reserve price at their level. Okay. Now coming to the next. So if these are the authorities, how we are going to make them? Who is having authority and what percent of reductions can be allowed? Okay, this is 10, 20. This is we have to remember. There are three cases, 10, 20 and 30. Okay, keep in mind 10, 20 and 30 for the examination purpose. The respective sanctioning authority, RSA is the respective sanctioning authority. Reserve price fixation is per occasion 10% reduction can happen. You have sold one property for say realizable value. Say it is a 1 crore, but auction failed. So in that case, the next auction can be done on the same property with the same valuation, but reduction of valuation will be the 10% on that. Means we reduce 10 lakhs for 90 lakhs again we will put for the auction, and that can be done within again 15 days. Okay. While speaking this also, I will tell the timeline of the auction period that when we are doing the positioning, when we are going for the reserve price, how the auction time will be there. In that time, I will also discuss what the 15 days and 30 days timelines will be there. Okay, so reserve price 10% reduction by respective sanctioning authority can be done. And who is respective sanctioning authority here is RO head CAC is the minimum respective sanctioning authority. Okay, 10%. Okay, because I told that up to the branch level, to the RH level, to the Sulabh level, up to RO power sanctioner, respective sanction authority is the RO head, 10%. So in case of again, I told circle power branch, PGM COCAC or GM COCAC at circle level, 10% reduction they will be giving. The next higher authority can permit the reduction in RP above 20% is the NHA. NHA can permit you to reduce the reserve price about 20% and up to 30%. Okay. Means you want that 1 crore property sold for the 80 lakhs or for the 30 lakhs. The NHA means now the traces of the branch, some branch account is there or RH account is there. No more regional head, ROCAC head will not work. Then COCAC has to give the permit, the 20%, 30% reduction. So please remember 10, 20, 30. Who is the 10? 10 is the RSA and next NHA is the 20 and 30. Okay. Any reduction above 30% has to be done, then it has to be permitted by GMHOCAC. 30% above, you want to make reduction of the property by stating that no, property is not sellable, the roads is not correct approach, it is not happening, that area is full of, the cry, the slum is there or nearby, the graveyard is there, we are not able to sell, then in those cases, 30% above, GMHOCAC only permit. Okay. And CGM, GM, HOCAC have a full power for fixed RP. Okay, in this case, one more case I have mentioned last is if auction, this is auction fails. Okay, this is the above cases and all are auction fails, then 10% reduction, 20%. But auction becomes successful. You put a property for 1 crore and 1 crore it is sold out. But the bidder could not pay the 1 crore in the stipulated timeline. In that case, what will happen? Whether we give the reduction? Absolutely not. So the reserve price should be more than the last successor, would be equal and more than the last successor, because already in 1 crore, that is a very practical thing, right? In 1 crore, we have all this already sold the property. One property has been taken by some party, but because of some condition, you could not repay it back. So in that case, we cannot sell it less than that price. So whatever the reserve price was there last time, that or more than that has to be happen. We cannot go less than of that. So this is about the all reserve pricing cases. In question wise, important is 10, 20% and all, and 10, 20 and 30 with the RSA and NHA. This you have to remember. Okay, 10, 20, 30 RSA and NHA. Okay, one more important for the examination point of view, two valuation needed, I am telling. So what is the two valuation needed? Where it is needed? Okay. When the security value is more than 5 crores, invariably you should take two valuation and the best value you have to consider for the sale purpose. Okay. Okay. In other cases, what two where we can take the two valuation statement where security is valued more than 2 crore in last sanction or last renewal. Last time what sanction happened or the last renewal happened, the 2 crores was the security value. And the reduction of the present value is more than 30% of the same. So now value while selling it, he is giving the less than the reduction is then 30%, means 3 to the 6, 60 lakhs gone down. He is giving 1 lakh 40 to your 40 as a value, realizable value. In that cases, again, we have to go for a two valuations. So these are the two conditions, very important for the examination point of view. Remember this 5 crores and 2 crores. 5 crores, anyhow, you have to do two valuation. But what is the 2 crores condition? It is a 30%. Then only the two valuations has to happen in this condition. Then we can go for it. Next. Okay. Again, the valuation of property when we are doing, I told already 5 crores one condition, 2 crores one condition, two valuation. When valuation has to be done, I told it is after taking 34. Although you have a valuation of latest some 2.5 years old, but you cannot consider that. So what you have to do is you have to take the latest valuation as per the surface value. And while doing surface, you ensure that that valuation is not old more than 1 year. That is what this point is. Wherever the valuation is more than old, you have to go for a next valuation. Suppose you have done the valuation, you have put for the auction, not failed. Again, you tried, failed. So after 1 year, again you are trying for the property auction. So that time the same valuation we cannot consider. The valuation given by the valuer 1 on the dated say X. We have to take new valuation with the date Y, means within the 1 year period. Then obtain the fresh valuation before e-auction. So before e-auction, that is this point is wherever the 1 year is old, you have to obtain the fresh valuation. And in those cases, again, reserve price will be fixed, RP will be fixed as per the new valuation, not as per the old valuation. And valuation, if any realizable value between new and immediate valuation to be, please, it has to be analyzed. If variation is more than 20%, then reserve price can be fixed by NHA only. Okay. So valuation of the previous year was 1 crore. Valuation now is 75 lakhs within 1 year, means 25 lakhs reduction. Properties usually do not depreciate, it should increase, but it has come down. If it has come down to below the 20% level, or valuation is or variation is more than 20%, maybe 78 lakhs, 78 lakhs like that came instead of instead of the 1 crore to be there 1 crore 5 or 1 crore 10, then those cases the NHA is the person who will fix the reserve price. So this has to be kept in mind as a section in charge or as a authorizing officer by doing surfacing. Now we have come to the part where we are going to sell the property. Possession notice given, symbolic is done, CGM is filed, we have vacated the property, physical possession is taken, well advertisement is given, and everything is over. Now SN means sale notice is to be created. So annexure 1, 2, 3, you might be remember annexure 1 is the 13.2, annexure 2 is the 13.4, and the sale notice is annexure 3. To be issued within the 3 working days from the date of fixing reserve price. Okay, we have fixed the reserve price from the date of 3 days from the position notice. So now again we have to start this position of the sale within the 3 days. The fixing of reserve price once is over, we have to make the sale notice ready. We have to send the sale notice. We have to fix the sale notice. We have to send in post. We have to fix it again like a position notice. We have to fix it. Okay. We have to also dispatch it and affix. And whatever that you have made affix, you have to take a photograph. That is the same as per the position notice you have to do. Okay. When we are doing this, I will tell one more point. Okay. Then when you are doing the sale notice, once again, the same thing you have to follow. You have to give the publication in 2 newspapers. One should be one other mandatory. And there is ensure that you are again sale notice to be dispatched to all the stakeholders, even sale notice, even position notice, all the stakeholders should get, whether borrower, guarantor, mortgager, or any other stakeholders or corporate guarantor has to happen. And sale date should be affixed with a gap of 36 days. When we are giving sale notice, okay, from the date of sale notice, law says from the date of sale notice, there should be 30 days time given to the customer. Okay, from the date of sale notice, 30 days time given to the customer. But very tactfully, our circular has taken 36 days. This is one of the important point to be noted for the examination point of view, because everybody knows that sale notice means 30 days time. Then examiner may ask, sale notice should be fixed with a gap of at least these days as per the new circular or 421/24. Then that time it is not 30, it is 36 days. Why? Again, this 36 days into the consider the same concept that while waiving the sale notice today, it may be chance that there is a delay in the post, there may be chance that he may receive it tomorrow, day after tomorrow, to keep that gap into the future. And very, very, very important, all these points, why I am telling that whenever you are going notice, giving notice, and whenever you are taking acknowledgements, whenever you are giving acknowledgement and take that whenever selling the properties, all these timelines to be very intact. It can be more, it should not go down. You got my point. Suppose 60 days is the time. It can be 65 days if you are issuing position notice. It should not be the 59th day. Please ensure that. On the position notice also, when it is issued, there is no timeline that within this sale happened. But sale notice when it is issued, it has to be ensured that 30 days clear cut time should be there. Within 30 days exactly, and don't be doing very hurry because the auction date has been announced by the RO. We have to do it. No, we have to be firm on that 30 days, because it is the stake of the bank. It is not the target. It is like not like a target, because if you are missing the date, if you are reducing 1 day or 1 hour itself, there may be a chance that you may lose the contest on the surfaces. Any cases has come. So which a case I was talking about the contest with the court in my own last branch was like this only, where the clear-cut sale notice date was given exactly 15 days. On the 15th day, it was been sold. But with the God grace and with our fight and with the lawyers and all with arguments, we could get it in our favor. Otherwise, we would have lost that case like anything. Okay, so don't be complacent in this regarding this notice which is issuing and maintaining the timeline. That is why I told again, and I'm telling. This timeline is very important in SurfAC. If you're not following it promptly, you're not maintaining proper in the file, it will be going to affect you like anything. Okay, it is going to affect the bank call. It is going to affect the bank reputation. It is going to affect the jobs of the accountability in the form of accountability. So during this 30 days of time, please ensure that sale notice, whatever you're putting, you are giving the pamphlets, you are putting the banner in your branch, banner on the property, you are talking to all your HNI customers, putting the WhatsApp status of the branch mobile numbers that this is property sale and all. So you can give the wide publicity for the sale to happen. This is to be ensured. In the branch notice board also we used to keep and pamphlets. And suppose property is your branch account, but property belongs to nearby branch. So that branch also you can send the banners and to keep the banners. Maybe in that vicinity people are interested to take the loan instead of your bank. Means you are in say Chennai, but maybe the property is at Bangalore you are taking. So Bangalore nearby vicinity branches also you can sensitize or you can give the pamphlets that please to popularize this notice. But in that bracket it is also mentioned here is 15 days in case of resale. I told reserve price is fixed, then you are giving the sale notice. So first clear-cut notice of 30 days has to be there. So now we called it that as a 36 days. We are giving the notice. Auction failed. Whether you can go for a re-auction? Yes. Within that valuation of within 1 year period, again you can go for a re-auction. The re-auction can be done within 15 days once again. Okay. That re-auction that I told you 10% reduction where you reduce the 10% price and you again put in the auction, that can be done within 15 days. Okay, so this has to be ensured. So re-auction you have to put and you have to go for a sale. This can be taken care into the consideration. Okay, so this is a very important and cubism process. I am taking surfacing more time because this is the one of the segment where I am finding that bank has given new circular. Means the examiner also will think this is the one important point. He may ask maybe what 2 or 3 questions, but we have to thorough with the all. And I have touched only the main slides, main point. How the circular was having the around 7 to 8 pages. I just tried 5 to 7 slides so that in itself you can have a great idea. Okay, on the surface, what is happening. Preferably on the date of sale. Once the sale is happening, sale date is coming. Successful bidding happened. Okay. So while doing the C auction also, we are giving the EMD dates and EMD times that for say 30 days of notice is there, we tell that on such a day, your EMD time is over. Means auction is say for the day after tomorrow or after 3 days. On 36th date, maybe the auction is there. So we tell that on 33, within this 33th day, you have to give the EMD. What is the EMD? EMD is the earnest money deposit. Who want to purchase the property, he will give his intention in the form of some 10% of money to bank in the form of a DD or FD or amount transfer, which we have to keep. Then we will give the login IDs to them. E-auctions for the nowadays bank is doing e-auctions only. We have to give the login ID passwords to them so that they can put the auction. So auctions will happen on the real time that you will quote 1 crore properties there started. Once auction is started, the system will tow 1 crore. The name will come. This person is putting 1 crore, 1 crore 5 lakhs. Somebody will put 1 crore 10 lakhs like that. It will be go for a auction. So online auctions only now available. So online auction is going to happen. So whoever is bidding successful on 36th date, you have put the auction and the successful bidder, Mr. X, is successful on that day or Miss X successful on that day. So in that case, what will happen? That the person has to put that EMD has given 10%, that 15% means that is 25%. That is what we are calling here 25%. Okay. Practically 25% on that day will not come because 10% we have already received. 15% of that amount, okay, that auction amount has to be put on the day of bidding, successful bidding, or within next working day. Again, this timeline is also very important. Why? Because if you are not putting this on the next very date, as per the act, the successful of the after the also successful of the bidding, as per the act, the surface is nil. because you should not sell this property to that person if he is not able to pay. So that whoever is coming into the picture, you ensure that he is having the 25% money in his hand. Otherwise, for the namesake, he is coming and is able to win and is not able to put, it will be a disaster once again. That also includes next working day. Suppose Saturday is the bidding date. It was the first Saturday. Bidding happened. So by Monday he has to put, not on the Sunday. Okay, by Monday he has to put it. Okay. So it has to be confirmed. Then successful. Once the bidder is successful, he has putting the 25%. We have to issue the confirmation certificate that in favor of successful bidder. Yes, you been successfully bid the property. Now you have to pay the amount within 15 days. So once successful bidding is over, the within 15 days from the bidding of the successful bidding, the party has to now pay the full 75% of the amount to the bank to get the hold of the property. Okay, maximum 90 days, which I told. So this is usually we give the parties 15 days time, but wherever party intends or is going for the loan, it is taking the time. So I already mentioned 75% should become within 15 days. But if we want more time, the circular is empowered to accept the sale proceeds in 3 months. So the circular is having the power to accept the proceed within 90 months. So this can be done with a ease. So in sale notice also, which I mentioned, the sale notice when we are giving and the PN, very in Dare Act book, if you say, because when you see the 421 circular, it is they have taken care of this, but it is a implicit condition. Condition says also, it is mentioned in the circular also. Condition says that when you have given a notice of 13(4), borrower has got the time of 45 days to go to the court. That is DRT. He can knock the door of DRT. Okay, you can go for a prayer or plea. So what it does mean is our sale should not happen before 45th day. Okay, you are given symbolic position. It doesn't happen that I told you within 3 days reserve price, within 3 days the sale notice has to be initiated. If within 3 days you are initiating exactly in the time, then what will happen? Then what will happen that from the date of positioning date, within 45 days, if this 30 days of sale will happen, your sale is again wrong. Okay. From 13(4), 45 days clear cut time should be there. After that only you have to have a sale in this. This is very implicit condition. Many times we miss it. Please be careful within 45. Usually in public sector bank in 45 days we don't sell it. But on the very aggressive manner, if you try to sell it and don't put it within 45 days, let it be on the 47th or 40th date, no problem. You have given 13(4), after 10 days you give the after 10 or 15 days you give this notice of sale notice, then exactly that 45 days norms will come. So on the 47th or 40th days, you can sell the property, but should not happen within 45 days. This is one implicit condition which is not mentioned as a condition in SARFAESI, but it is an act. This is lawful, very lawfully you have to ensure. So action under SARFAESI, I already told you should not stop it. Nobody is empowered to stop. Only circle had permission to be required. I told you, but once you give 13 to party will come, sir. I'll come and close out. Yes, sir. You take this 10%, sir. I'm closing, sir. Like that, you told that, but it should not be. Okay, it will be stopped when the full overdues is coming to us. Okay. Okay. In which simultaneously, one more thing I want to tell that initiating, somebody told it a SARFAESI is a legal action. No, why is it legal action? I told that time because SARFAESI is not at all related to any limitation. Okay. In between the account, if it is going to be expired, suppose some account you are initiating SARFAESI, say we tell that mortgage properties we have a 12 years of limitation period. Correct? Housing loan, mortgage of 12 years of limitation. Okay. So maybe on the 12th year it become NPA. Okay. So on that in that case, ensure that on the 12th year it is became NPA means our limitation is going to be over. We are not going to, because in housing loan our the limitation law circular says that we need not to take the AOD that 3 years timeline. We have to take it on the if it is overdue from the overdue to within 3 years or from the 12 years, 12 to 12 years. Okay, it is called AOS and AOD. It is a acknowledgement of debt and acknowledgement of security. That AOS and AOD we have to take on 12th year. So you are thinking that on the 12th year it is getting NPA, that 11.6 years it got NPA. 6 months time is only there for you limitation of period. You have initiated services. Don't think that your document is time not time barred. your document is going to time bar within 6 months. In between, you have to initiate all this process, that the 606 or 607, which is applicable as per the law, as per the loan account number. And wherever it is required, you filing the transfer to the CR file to the recovery section, or where you have to mark the new flags. This new flags has been given. Suppose 607, you have sent some accounts for the legal waiver. You have to mark in 159. You have gone for the taking the permission of filing suit. You have to mark suit file permission got with that reference number. Then you have to take care, very importantly, the limitation in surface C. Then within that 6 months, you have to also file into the DRT, that cases. Okay. It is very, please be very careful. That's why in the first question I asked whether it is a legal method, non-legal, or not. Many of the people, they told legal method. If would have been a legal method, the limitation would not have been come into the picture. But it is not a legal method. Only when file moved to DRT, there starts the legal method. So surface C part 32, 13.4. Okay. So it is a legal method. To ensure that it is not a legal method, because limitation is one part, you have to ensure that your document is not going time bar, because surface is separate and time bar is going to separate. That if it is going to time bar, file a DRT as early as possible. Okay. And for the decreed account, where the account decree has come, court has given the order, DRT has given the order, where assets is available, there also bank can go still surfacing. Even usually in the DRT also, when you go to court, they will ask whether surface initiated or not. The judge himself asks why you are not initiated surface, why it is stopped and all. So we have to continue our action, stop not till the recovery is made. Okay. So as per the circular, once again we have this idea. They can ask the full form of SUFFLE. What is SUFFLE in SAS? This is the one package they have given, stress asset follow-up and litigation package. Where in SAS you can put it. They have given the option of putting the data entry on the surface to monitor the surfaces. They are given this timeline. So how to monitor, how HO will know, how circle will know whether you have initiated or not. So once account become NPA data will be uploaded in the SUFFLE package. Then this data entry has to be made. Then 13 to 13.4 we have to generate. And those generate dates will be taken into the consideration for the further follow-up, and the sale and optional details, everything will be coming into detail. So SUFFLE is one of the important stress asset follow-up and litigation package. So this full form may be asked for scale 1 to 2 or 2 to 3, not for 3 to 4 at least. I'll finish surface, then I'll take one break. It is almost 12. For that, I'll be finishing this. So in surface also, while selling, I told that in surface, when we are selling the property under surface, we have followed the procedure. We have sold the. We are trying to sell the property. It got failed. Then we made trying for the property for the second sale by reducing on the 10% and putting it again. It may fail one more time also. So those cases where the property we are failing in the property selling the property as per the Ministry of Finance guidelines. Okay, at least accounts. This is also one important. Please note down 101. Okay, 101 to try to remember where can be private sale. This was the last year 2 to 3 question. Where can be the private treaty is possible? Where reserve price or assessed value is less, property reserve price or assessed value is less than 1 crore, less than or up to 1 crore, means including, this is including 1 crore, okay, up to 1 crore, including 1 crore, then one attempt might have failed in the property sale. Then you can go by private TT sale. What is private TT sale means? Suppose we have tried to sell the property, not happened. Then another one HNI is ready. He is telling that I can take this property. Then you call that HNI, let the party sit in front of you. They will discuss, they will negotiate. If that is happening, we can go for a sale. So that is the private TT sale. So, but property more than 1 crore is coming 2. Okay. 1 and above 1 means 1 into 2. 2 attempts has to be failed. So what is the 1 crore? 1 attempt has to be failed. If more than 1 crore, 2 attempts should be failed. If 2 accounts fail is happening, then we can call for the private treaty sale and we can close the square of the matter. Okay, this can be easily done by our as a banker. So that is not exactly part of a surface sale, but it is just like a normal sale. But it can be also resorted in the case to case basis, not every cases. With up to this, I will take a one break. It is almost 2 hour session I made. 1 and 2 more hours is there, so we will try to finish with more than 1.5 hour. So, Silvaji,
Yes, sir, we can have, sir.
we'll have a call for a break for just 10 minutes. Okay, have a
Yes, sir.
water, tea, and have a crack jack, Britannia break, whatever it may be. So you can run our break video, sir. You have no?
No, sir, we will have up to 12:20, sir. I will pause the video.
Okay, then 12:20. No, I am telling that to run the advertisement. No, till the time bank advertisements will come on.
No, 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 no such thing, sir. We don't have such facility.
I'm just joking. I'm kidding. Okay, thank you, friends. Just take a. We'll be reaching it just within sir 12:20. What you're telling time?
12:20 we will start, sir. 10 minutes you
Okay,
said.
it's 10 minutes break. Yeah, thank you, thank you, thank you.
Okay,
Just
sir.
let be more comfortable on doing the surface aspect, because I already told that surface is such a act which is given power to us, but we have to be very responsibility. If we are not doing, then we'll be in a soup, because borrower can take any advantage of loophole and it may cost us very badly. Just one case which I told, which I have experienced in my last bench, which I told, where the surface sale happened. After happening the SURFACE sale, borrower has gone to DIT and challenged our SURFACE after 6 months. So we were fighting that case. Some loophole economics were there on our part also, but we could anyhow manage, able to convince the judge that the lady borrower is a chronic. And many a times SURFACE has been done, whatever that she is claiming it is wrong. Then judge was anyhow got satisfied and given the verdict in our favor. Otherwise, it would be costly. There was even ready to make a verdict to reverse the SURFACE. Means reverse the SURFACE means we sold the property, means we have to get that property from that borrower, then we have to give it to her, then we have to pay the amount to the borrower, all these things. So another litigation with the borrower ask the interest why you have taken this in. Okay, so we have to be very careful. And when surface, when we are dealing, we have a surface agent who is taking care of it. So henceforth, my slides will be the informative only, which is only examination point of very important to you. So wherever it is there, I'm highlighting the data. You just make a notes of that. Who is empowered to empowered to empanel the surface agents is circle heads. Okay, circle head has the empower power. And the review will be done on September 30th and March 31st. These 2 days. They may ask that review will be done by whom, and by whom will be the whom by the wing of the head office. Okay, review will be the head office, but empaneled by the circle head, sir. And can be utilized. The service can be utilized. I already told for the courts and asking the CMM orders, taking the physical position and all, and wherever it is felt and necessary, we can use it as time to time basis. Okay. Now coming to this part, fee payable to surface agents. So last time, all the columns, one question was there. The first column was a question for 1 to 2, 2 to 3 was the second question. For us, we got it as a third row. This was the 4 to 5 question was given. So what is the fee payment structure? Screen will be is very important to please ensure that any pre-inspection Caesar. This is all the memory game. Examination is not a promotion examination, not as the examination for selection. I believe it is the examination for elimination. They will eliminate the weaker one. So you have to be very strong in the presence, strong in the knowledge, strong in the memorizing the things. Then only the things will come up. So you have to give your best. You have to make the best things to happen in this 1 week of time which you have in you. Okay, take proper care of keeping the things intact and memorizing the things. So pre-inspection, pre-seasons activities, anything they are doing, they are entitled to get the 2,500 minimum, maximum 5,000. It is case to case basis. And who is giving RO head here? Always remember, our regional office only going to give this payment. All the regional office level power, including branch and whatever branch RH. Okay, up to regional head power, RO only going to make this payment. For obtaining order from magistrate, CJM order, we are telling under section 14, CJM order has to be made. So when they're going to make the play, all this documentation, typing, filing of the suit, we can do it. We can give the payment. That is 25% of the value of the movable immovable property. That is whatever the value we are assessing. Maximum that amount we can give, and we are giving the case to case basis. It is not that the 1 crore property 25% is 25 lakhs. You have to pay 25 lakhs. No, it's not like that. So what is the 0.25% of the value? And minimum is 10,000 up to maximum 30,000 can be paid to the surface agents. Assistance in taking the position of movable means when we are taking the physical for our circular says for the symbolic position. Our question may be asked for taking symbolic position. What is the surface agent's amount we have to pay? 30,000, 25,000, 2,500, etc. Not none of the above. So answer will be please make a note, none of the above only because circular specifically says that for symbolic position we need not to use him. It is only for the physical position and CMM order. Symbolic position if you are using and if it is asking payment, you should not pay it also. Okay. So there is no payment structure is also discussed. Nothing our circular says that for symbolic position they are going to be used. What I am telling is not on your screen. It is just you have to remember or you have to see the recording or keep a note of in the copy. Okay. This is all the circular because all 279 pages of circular I cannot put on the screen. It is more hazy. Okay. So in case of taking position, the movable is up to 25,000. Movable means car, trucks, and all whatever. And symbolic position, there is no need to take. This is already there. We have told a sum of maybe 5,000 to be paid. And actual position will up to 50,000 is the amount. That's only I told symbolic position. There is no need to take the consolidated one. Okay, and the consolidated amount of 5,000 can be given maximum. So they need not to take actually. If you are asking also some the other charges or for symbolic creating the boards or something else, the maximum you can allot the 5,000. Actual position you can pay and up to 50,000 is the amount including. And additional expenses also we can give case to case basis, any extra. And that is again AGM power. So any additional cases which anything can be given means that is a case to case basis only. Okay, that is as per case. Suppose some cases police has come and the executor attorney has come. We are making out of our pocket expenses to bringing them to dropping down them out and all. So all those cases, whichever is there, if anything is there extra is going, then that has to be taken care separately and case to case basis only. Okay. So amount payable for the assistance of officers taking position. If you see. Proportion shall not exceed 5 lakhs. This is the one last year. I think this was the question for 4 to 5. They asked not exceeding 5 lakhs. What is the maximum payment we can be give is 5 lakhs or 2% of the reserve price, fixed price for the property. This is the maximum for the cases of the positioning, physical positioning and all. What we are doing, officer who is taking the physical positioning and including any extra cost. Means all surface proceeding include should not go to more than 5 lakhs. In addition, incentive can be given of 0.25 lakhs or 1 lakh, whichever is less, may be permitted for the recovery made within 6 months. If recovery is making 6 months, okay, and I think this the data has come down wrong. It is not 1 lakh, it is 2 lakhs. Please make a note of this. It is 2 lakhs, not 1 lakh. Okay, as per circular, it is 2 lakh. It is old data. So 0.25 is the maximum, but within 6 months the recovery should happen. And if it is recovery should happen, then you have to you can give the incentive. And this is over the above limit of 5 lakhs. What are the 5 lakhs we are paying here? This can be over and above this, and that is 2 lakhs now. Ravi sir is in the session. Please check up on the circular. I think remember it is 2 lakhs, not more 1 lakh. Okay. Then bills to be submitted of the surface agent to be paid in 10 days. Okay. I told that I answered my slides to the informative, which will help you to just answer the questions where the questions can be asked that what the numerical sites and all. Okay. Where the numbers will be the game. Okay. You have to remember much of the numbers. Okay. I already told the payment of the surface agent shall be by the regional office. Okay. As per the delegated powers, revenue expenditure. And for the circle level, there are circle level powers. Okay, if suppose the surface agent brings the successful bidder, he is entitled to 1% of the realizable value of the property. So whatever the RV, realizable value of the property, or the contractual rated, whichever is less, he will get the 1% of that. So realizable of the property is say 1 crore. Contractual value is only 50 lakhs. So 1% of that he will get if he is getting the successful bidder and he is entitled to that. And minimum of 10,000 to maximum 3 lakhs including GST. That is what the payment norms is 1%. Should not cross. That is minimum of 10,000 and maximum up to 3 lakhs. So this is the successful bidder case. This does not include the 5 lakhs which I told in the previous slide. Okay. So previous 5 lakhs which I told is the total proceeding costs. What are the proceeding costs? Maximum that goes to 5 lakhs. And the incentive can be given 0.25% to the customer if he closes the case within 6 months. That is successful bidding. Everything is happening in within 6 months. And with successful bidder also, he is getting on the successful bidder that 1% also we can give to them. Now coming to the slide where the reporting of the frauds, who is going to, we are going to report. So above 10,000 but below 1 lakh cases, any frauds is there in the branches happening means the agency whom to report is state police and lodged by the branch head. Okay. And above 1 lakh, this slabs you have to remember 1 lakh to 6 crores. This slabs is changed newly. Previously the slabs was 3 crores like that and now it has been changed and that was up to 25 crores. Now it has changed to up to 50 crores and more. So 1 lakh above but below 6 crores. It is CID. It is a state wing. Okay, state CID economic offense wing. It is a CID is a state the detective agencies. So we can put the state up to 1 lakh from 1 lakh to 1 lakh and above to 6 crores. And who will lodge RO head and executive not below the rank of AGM. Then 6 crores to 25 crores can be lodged with the CBI by circle head only. In all the cases, circle head. So it is very easy who is going to lodge because only 3 cases. The only thing is you have to remember this table. And CBI also 3 cases are there. Okay, so it will be also very remember 6 to 6 to 25 crores, 25 to 50 crores, and more than 50 crores. All are CBI. Only wings will change. First wing will be the economic offense wing. Second will be the banking and security fraud cell. And the third will be the lodge with the CBI wing GEO complex. This is lodged with the head of the zone. CBI head of the zone, New Delhi has to be lodged if it is more than 50 crores. Okay. So this is again one informative slide. You can make a note of it. Now coming to the fees to professional fees to advocates. So advocates we are using for the filing DRT cases, court cases. How much we can go into pay them? The first this line itself is the last year 4 to 5 question. Okay, what is the AGM headed powers up to what is the power they can pay to the professional fees to advocate? This was the question last year. So professional fees to advocate maybe case to case, whatever the case they are filing, it can be done. This is the fees is separate than the court fees. Please remember, this is not the court fees. It is separate than the court fees, and up to 2 lakhs is the regional head power. They are permitting case to case basis as per the file. And the circle head has the power as per the GC's power and our CGM and FLP wing has the full power. That is the full power account. So the wing power is having the full power in this case for paying the professional fees to the advocates. Okay, fees payable to advocates in original application filed before DRT. Suppose in DRTs we are filing the case. So how it can be? So there are 2 cases are there in this. DRT filed before non-metro cities and DRT filed in metro cities. So if it is a non-metro cities, OA I am telling the 20 lakhs because we know the DRT 20 lakhs about to be filed. So 20 lakhs to 25 lakhs is the slab of the cases. We can pay in non-metro branches 25,000 for suit amount and suit amount of rupees 20 lakhs and 1,000 for every addition of 1 lakh maximum 30,000. So up to 25 lakhs, what is there? 25,000 can be paid up to 20 lakhs. So every addition of 1,000 for every day maximum that it can be up to 30 lakhs. Okay. This is excluding GST, not including GST. And 25 lakhs and above cases, it is minimum 30,000 and 250 for every addition of 1 lakh subject to maximum 50,000. This is the case where we are going to have in non-metro cities. Where DRT is in the non-metro cities. Okay. DRTs are there almost in every metro city. Some non-metro cities DRTs which is classified. So those non-metro cities DRTs when you are filing the cases, then this is the condition that up to 25,000 we can pay plus 1 to 1,000 every addition and 30,000 every addition is 25 to 50 lakh. Okay. Okay. Now, sorry, I mentioned non-metro. It is not metro. It is metro cities. Okay. So in metro cities, when we are talking about file before DIT is in the metro cities, then in that case, the same 25,000, 1,000 addition, 1 lakh, the same is continuing. Uh, the same 25 lakhs and above, we are continuing with the 30,000 every addition with 50,000. Data has been changed here. No, I think friends, sorry, I think data has been wrongly mistaken here. So 50,000, this amount which is coming, it is for the metro cities only. Non-metro, the data is wrong. I'll share the data for the non-metro before the ending of the class. Ravi sir is there to help Anna. Ravi sir, please check the circular, sir. I think if you have means I can take a help of you. Now coming to the incentives to advocates. When advocates are filing cases and making the EP or recovery very effectively and making within the timeline, then we can go for an additional incentive for the advocate apart from the professional fees. That is recovery made by filing EPs, execution, artists and DRTs and non-DRT cases, 2% of the actual recovery, subject to maximum 1 lakh, 1,50,000 we can give. And where the decree obtained within 6 months, means we have filed the case and decree also obtained within 6 months from the date of filing case in DIT. It is a case of DIT because DIT cases usually it goes beyond 1 year, 1.5 year. But if he is able to do in 6 months, then 20% of the entitled fees should be paid over above the scheduled fees. So whatever the scheduled fees we are giving, 20% entitled fees we can give over and above that. And decree passed RT issued within 12 months from the date of filing suit. If that is happening, then 10% of the entitled fees should be paid over above the scheduled fees. So within 12 months, whatever the decree which is there, we are able to issue the recovery certificate. Means decree we have able to got from the DRT, and that decree is implemented in from the recovery certificate. Means recovery officer has gone and attachment for the attachment of the properties. In that case, 10% of the entitled fee shall be paid to the above. Means 20 and 10. Means the additional 30% he can easily earn if he is able to move the case 6 case in case of decree, 6 months in getting the decree and 12 months to finish up the RT. Okay. So with all information, that information is just for the remembering because those information is helpful only to get you some informatory question marks as marks if you are getting that it has to hit your mind and you have to answer the question. Now coming to the compromise policy guidelines. Already Jagannath sir might have taken this class I think 2-3 days back, which I know. But just on the point of because the recovery policy also mentions this compromise policy. You have seen why what is the we have dealt with that what is the cases, court cases, legal, non-legal cases. If legal cases we are doing, we are knowing it as how much we are investing the money, time, court, and there is a तारीख पे तारीख मिलते जाएगा है ना and all what we call it as surfacey when you are doing you have to be very meticulous, you have to follow very specifically timelines, dates, acknowledgements, everything to be intact. So if this much of it is a cumbersome process and it is a kind of a threat as well as a risk to the bank if you miss something. So compromise policy guidelines gives one of the easiest way to the bankers that to settle the things amicably with with a amount which we are insisting if party is ready to pay, we can close the case and we can get rid of it. It means no more future cases, no more anything. But the only thing is you have to give the properly the policy as per the policy we have to settle the account. So eligible NPA accounts are who has completed 6 months from the date of NPA or legal action has been initiated and everything is taken care, but not can happen, then we can take a 6 months. And there is a concept of cutoff date in compromise policy. What the cutoff date will take for the policy? The cutoff date is maybe your NPA date, or in some cases it is a sickness date that industry has got 6 months back, but NPA happened after 6 months. So we consider the sickness date itself is there, and how sickness will be shown? Sickness will be shown in the form of a SMA accounts. Okay. So in compromise policy also settlement policy, I will not deal with much. I just want to highlight one important thing that settlement policies will be taken on the decisions on the basis of case to case very prudently. And what is the basic settlement we can do in any condition? No specific circular, nothing. If suppose one customer has come, you want to make a thumb rule. How we are settled? You just see what is the realizable value of security is sufficient to cover the contractual dues. So as per the matrix, it is 0.8. They may ask the points also. If the realizable value security is sufficient enough to close the contractual dues. Maybe due is 50 lakhs, property is 1 crore. So 8 points. So what we have to cover is, we have to recover is book liability plus simple interest at the rate of MCLR plus 2.50, and the MCLR date is 1/4/2024. What we have to take as per policy right now. Next year policy, it will be 1.14 to 25 maybe. For right now, what is the MCL policy? We are telling that 1/4/24, what is the MCLR date? That MCLR plus 2.5, simple interest we have to calculate that from the date of NPA into book liability, and that amount we can collect. If that amount also we can collect, we can easily we can easily close the account. So that matrix is 8, where realizable value of property and net worth put together is equal to contractual dues. His net worth as well as property is all put together. Means what are the securities he has given to us with that, and what is the other securities he is having which is not going put together, is sufficient enough to close the contractual dues. Then in that case, matter 6 then what we have to collect is book liability plus simple interest MCLR minus 0.50. That interest we have to calculate, book liability and this interest we can calculate, and we can take this as a outpay settlement. But most of the cases we see that small loan, very small loan, where realizable security is not there, no net worth is there, no unit is there, nothing is there, where you can put customer is diseased. That in those cases also like matrix 4, and the policy says please recover maximum amount the policy keeping the realizable value of the security. Some unit itself be not there, it is 0. So what are the maximum possible amount he is giving us? So that we can give to him. So that we can settle the loan. So this as per the matrix, we can go for a settlement. This is what the policy guidelines says as per the compromise policies. Okay. Next, coming to what this circular, I told that my dealings in this lecture will be totally basically on the policy 247, 421, 688, and 544. So latest modification one has come, that only I will just I am highlighting here. And this modification is again important from the examination point of view. Why? Because this is the latest amendment in the policy. Policy, it was up to 25 lakhs. So question may be asked as per the I have seen last year also. That question was very specific with quoting the circular number. If he is quoting the circular number 247, that is up to 25 lakhs. If he is quoting the circular number as per the 688, this is as per the 50 lakhs. So the new modification what has come, that in case of the agriculture loan which become NPA, and it is NPA more than 12 months old. Okay, and it is a restructured, repeated, RRA is the repeated restructured account, and it is a substandard category account, combined limit up to 5 lakhs. Those cases, how we are going to settle? We can settle the loan amount up to 5 lakhs of DF1, DF2 loss or repeated substandard after 6 months of slippage of NPA. Original loan amount disbursed less recovery is made. What is the condition I am writing on the right side? So if loan sanctioned up to 5 lakhs is there, whatever the loan DF1 means doubtful 1, doubtful 2, loss account and repeated restructure. No substandard account here, please. Only substandard with repeated restructure only to be allowed. And that too after 6 months of the slippage. Okay, or other cases, it is the 12 months of slippage. So when I'm telling 12 months, automatically DF1 come into the picture because substandard is 12 months. So DF1, DF2 is starting, but it is a repeated restructure only. Then only we are taking into the condition of 6 months of the slippage. There, what policy says is you have to collect the original amount which you have disbursed. Okay, less recovery is made. You have disbursed 1 lakh rupee, and you have made a recoveries of say 1,000 rupees, 2,000 rupees on debt. In between, debt waiver has come, say 10,000, 40,000 rupees. So now 40,000 debt waiver has come, and we have given 1 lakh. So 1 lakh minus 40,000, 60,000 you recover, you can settle the loan. Okay. Loan sanctioned above 5 lakhs and up to 25 lakhs, the conditions are differing. So loan sanctioned above 5 lakhs to up to 25 lakhs. Loan sanctioned above 25 lakhs to 50 lakhs. So up to 25 lakhs one slab is there, and 25 to 50 lakhs one slab is there. So up to 5 to 25 lakhs, if it is a case of DF1, doubtful 1, then original loan amount, whatever he has taken, simple interest of 6% from the date of disbursement to previous quarter, means from the date of disbursement when was disbursed to previous quarter. We are right now in the December quarter. So up to September quarter end, you have to take the calculation, simple interest calculation month-wise. Okay, 6%. You have to calculate, add with the original amount, that amount we have to consider for the OTS settlement. And If it is amount about 25 lakhs up to 50 lakhs, then original loan amount plus simple interest 7%. Okay, 25 to 50 lakhs, it is increasing, 1% is increasing. 6, 7, 4, 5, 3, 4. You see the chart, it will be there like that. 6, 7, 4, 5, 3, 4. Only 5, 4 will 6, 7 is there, 5, 6 is not there. Okay. So 6, 7, 4, 5, 3, 4. So slab will be 25, 5 to 25 lakhs and 25 to 50 lakhs, DF2, DF3, and loss account I already told. Whatever Ola means original loan amount minus whatever recovery made, whatever we are getting, we have to do it. And also in loss account cases, also to assess that if it is coming under matrix 4, as per my previous slide, if it is matrix 4 means party is diseased, the party is not there, no land records, nothing is there, we can consider the maximum permissible amount also we can be considered. Okay, that is the case to case decision has to be taken. So this slide will be one of the important slides, which can be the part of mind of the examiner, that he may think that this circular has come, maybe he put for the up to place. So the 25 lakhs has been changed to 50 lakhs now. So timeline of OTS, what is the OTS timeline? We usually at the branch and RO sanction maximum 3 months. CO sanction can give maximum 6 months. This is the one important question. Maximum tenure is 12 to 18 months. But who can give the 12 to 18 months? Maximum 3 months for the RO power, CO power 6 months. HO power is only maximum 80 pounds. So if any settlement happened, up to 18 months, HO can give up to 18 months, you can settle the loan. Okay. So, but branch level, whatever the RO sanction is, maximum 3 months time will be there. Within 3 months, he has to settle. If he is not settling within 3 months, then we have to take a appropriate interest from the date of the settlement, and then we have to give that amount to the okay. So this has to be taken into the consideration. Okay. Okay. In case of no due certificate, in respect to account settled under OTS. So when you are settling under the OTS, please be very careful. People will come, they want the no due certificate. You have to give the no due certificate. When you are giving the no due certificate, it should be ensured, indicating that borrower has settled under the one-time settlement as per scheme of RBI or bank, whatever it may be. The circular numbers you can quote and you can give as per which circular. And in case of group account, there are 4, 5 accounts are there. Unless and until he closes all the account, do not give no due certificate, please. Okay. And in case of return of account, no due certificate should not be. Return off means it is a prudential return off. Bank has written off. Many accounts will be there. It is condition is written as the written off. In those cases, you should not give no due certificate because it is written off by the bank's own fund. It is not his fund. Okay. When OTS will be there, then in that cases only we can give the no due certificate. Okay. Now coming to the legal notice, why I put this slide is many people will think that legal notice we are sending from the branch, we are the empowered. The questions will be asked for the theoretical side, no practical approach. So who can issue the legal notice? First question. The legal notice can be issued. Legal notice can be issued. Regional and circulars are empowered to permit the issuance. So you want to issue any legal notice to any customer, circle and regional heads are the empowered. Okay, you have to take the permission. Many cases you might be doing at the branch level, nobody will ask the question, but this is as per the circular. Okay, and the answers should be as per the circular. So, regional head and circular heads are the empowered in while sending. When you are sending NF 607 to RO, we seek permission to issue the legal notice wherever it is applicable. Circle heads are empowered to permit the issuance of legal notice respect to sanction made by the CG, CSC and all. Okay, circle head is only this power, and regional head is up to the branch level powers. Okay. Okay, now coming to the bank has a write-off policy. Why I am included this write-off policy? We know that survey OTS is one of the very easy negotiable settlement through which we can settle the account. Okay. Now many branches might be having very old accounts. The parties are not traceable. If you go for a suit filing, you may not have AOD. If you have AOD also, if you file a suit also, you cannot able to trace the parties. Please ensure those type of cases where already you have initiated surfaces sale happened, but after that no properties are there. Nothing is left to sell those accounts. The properties are sold, the whereabouts of the borrower is expired, whereabouts of the legal heirs are not there, and no legal heir is there also. They are also not ready to pay anything. In those cases, you have to take for the prudential written off. Or sometimes bank also wants that why to keep all this unnecessary things in my book. They want to clear it off from the book. Book in the sense, bank book they want to wash. Okay, balance sheet. The shit in the balance they want to clear off. So those cases also they will try for the right of prudential right of bank will write off the account so that bank's balance sheet will be very clear, it will be clean. So there are norms where which accounts, whether every account we can do, no, what are the accounts we can do, the criteria are there, and those criteria are important for us for the examination purpose of okay. So accounts in the books of may include and which, so we want to clean the balance sheet, so we want to get the prudential. What are the conditions? Completed 5 years from the date of advance. Okay, from the date of advance, it should have completed 5 years, and it should have a minimum 3 years under NPA as a NPA, and classified as a loss in before 31st March. Means one account should have completed 5 years. Today, I want to make any account as a prudential write-off. I want to bring into one account to say 1 lakh rupee. That 1 lakh rupee should have already advanced before 5 years. And since last year it should have been an NPA, and right now it should be a loss asset as on 31st March. Right now means as on 31st March means 31st March 2024, it should be a loss asset. Then we will make it under the prudential write-off and we try to do the write of the accounts. Okay. Okay. So write-off, when I'm telling it is not OTS, means it is bank is writing off from their own funds. So what is the power written off power? So last year only this was introduced. Before that there was no write-off power. They have removed the write-off power from the regional head and the circulate power. Previously it was there. After COVID they have removed. Now again the last year onwards they have bring into the last year the question was also there for the write-off power. This year was also maybe expected because most of the people they think that RO and COs don't have a write-off. So that is the inclusion. That is why bold also it is there. The RO at CAC up to 10,000. Write-off means including with the waiver and return of amount put together. Okay, unpaid interest with including unpaid interest. And circle at CSC has the up to 25,000 power. So this you have to consider because these two are the important newly added in the last year only policy they have added. So that is continuing. So this is a point of view. One is important that arrowhead CSC and circlet CSC has the power of 10,000 and 25,000 respectively for return of. Previously it was not the return of power. Okay. Okay, whether while doing OTS, whether we can sanction loans to the borrower if we want to do OTS. Yes, it can be sanctioned, but it should be a non-willful defaulter. He or she should be non-willful defaulter. But we have to maintain that cooling period. So circular I have already quoted on the screen. 125.24 is telling us the cooling period concept with the sacrifice amount. So what is the sacrifice amount he has made, including our OTS as well as other bank OTS. If somebody has done the OTS outside, settlement has been done outside or including our bank. If the cooling period, we have to follow the norms as per the 125.24, 2024. In this case only, as per the cooling period, we can go for giving the fresh lending on case-to-case basis again. And fresh finance up to 50,000 may be considered for the respective sanctioning. RSA can do this for who is non-willful defaulter under agriculture. If you want to give some agriculture loan unsecured one, we have a 1.6 lakhs of that renewed on KCC. He has done the OTS. So in those cases, we can after cooling period, we can consider case-to-case basis 50,000. Okay, gold loan is one of the important. Whether this is a very interesting point for the examination point of view, whether you are able to give gold loan practically on the ground, you will be giving gold loan to all. Okay, you will not check the CIBIL, nothing and that. So that is why the examination may ask this question. For gold loan, somebody has come for taking the agriculture 836, 842 products. Somebody is taking. Who can sanction? Yes, if he is the default. Actually, as per the gold loan policy, we have to take the CIBIL also for the gold loan, but we are not taking. That is a different issue. But for examination point of view, respective sanction authority can sanction gold loan up to 1 lakh for the minimum cooling period of 3 years. Suppose somebody has settled today loan. In your branch only, somebody has settled the agriculture loan. Tomorrow he wants a gold loan from you. So in that case, cooling period of the 3 months is to be there. Okay. So in the 3 months, you can sanction maximum 1 lakh under agriculture. And from the date of clearance and compromise, if it is completing the full 6 months, then you can sanction the full amount as per the gold value and all. And till last year, it was a although it was technically said in our circular, but practically not implemented in labs. So in labs, we use not used to get this customer to give the gold loan. We used to go for a CHX 14 or something. We used to do to give the circle permission and all. Then only it was the clearance used to happen. So right now, I don't know what is the condition branches were able to do or not. Okay. The in that write-off and prudential concept only technical written off. Last year, bank has brought this concept that to clear up the balance sheet. I already told the same condition where technical written off where which we are proving that accounts classified as doubtful more than 3 years and loss assets which has been remained NPA continuously for at least 2 years. Loss asset 2 years and doubtful assets more than 3 years. There we have given a technical written off. This is another, apart from the prudential write-off, this is a technical written off concept where we have written off the balance sheet only in our books of account. But you might be seeing in your CBS. In your CBS, the account will be, account number will indicate, you are having a document, everything will be there. But in backend, it is already written off. So that we last time when campaigning came, two lists was shared to every branch. TWO, that is technically written off list. So those lists, they are told that if you can settle for any minimum amount is coming, you settle the accounts like that it was told. So technically written off accounts, we can settle it. So that account, the classification, only the difference between the prudential and technical is prudential is only loss accounts more than 3 years. Here loss as well as doubtful asset more than 3 years, they are written off from the back end. In CBS it is there, but in the bank books it is not there. Again, once again, I'm telling there is a difference between the prudential write-off and technical write-off. Technical write-off only for the balance of the banking balance sheet they have taken out, but your CBS, your books, your documents will be intact with you. Okay. They have also even removed many accounts with the assets also. Where some small estate agriculture only there secured assets. There also they have given a technically written off. Okay. Accounts declared as fraud, willful defaulters cannot be taken into the consideration. This is the everywhere in compromise settlement, in technical return of, in prudential return of. If it is willful defaulter fraud accounts, you cannot go for it. Okay. Accounts granted by CHMSC also shall not be considered. So these are the just information you just have to remember because they may ask odd man out, which is not applicable as per the technical return of account. Okay. Okay. Recovery through Lok Adalat. Again, what are the highlighted portions are the things which you have to remember can be handled cases up to 20 lakhs. No court fees, no advocate fees involved. Only thing is you have to arrange the Lok Adalat in the premises of the court. Usually the Lok Adalat will be there in the premises of the court only. So there you can entrust, you can send the notice on behalf of the court. People will come. It is done on mutual consent. It is not that Lok Adalat is given and party told I will pay 10,000. You have to accept. No. If bank is accepting, party is accepting, then only we can go for closing this accounts or you can accept this account. And once they have given the order, court has been given order that on 1 lakh suppose some settlement happened, that is equivalent to decree. Okay, it is we call as a Lok Adalat decree, and it is also enforceable in court. Once why Lok Adalat is very important. Some small cases, 50,000, 1 lakh cases, you send this notice local, people will come attend and they will settle the cases. If they are agreed on some amount and not settle the cases, okay, those cases, what we can do, we can take the decree and they can enforce the law. Your document is enforceable. You need not to run behind that document again and again. Okay. So to get the AODs and all. So this is one concept. And permanent Lok Adalat is the concept where in some state, in some districts only it was implemented. When I was there in Anandpur, it was implemented. It is a very beautiful part of a court. Without any court fees, I was able to file the cases just like court. And whatever the cases we were filing, if party is not coming, they used to pass the ex parte decree. Means my favor, they used to give the cases. And my document is saved for limitation. For limitation purpose, my document is saved. If party wants to challenge this also, he has to go to high court. He cannot appeal in the district court. Okay, the next higher court only he has to go. So appeal has to make the next. So this was the one case, and the limit for this is 1 crore over there. Okay. So award, whatever I am told, let's just know, whatever the award is equivalent to decree only. Award, they will give the award by meeting the party, both bank and party sign, and also the judge sign, and the Lok Adalat members also they will sign, Lok Adalat members. So it is equivalent to decree. If you are using this, this can be an easy way of recovery, and it is a legal way of recovery. Although it is a legal way, but I already mentioned that they will ask Lok Adalat is a legal way or not. Because when usually those on the practical ground on the field, no, they will think that no, it cannot be a legal way because it is a just consent. It is not that court is passing any decree. It is both consent happens, then only court will pass the decree. Otherwise, no. Okay. Now coming to the LOC, not it is not a line of control. It is a lookout circular. Again, informative purpose only. I kept this slide. This is a chapter of some 5 pages, but I have kept scripts for the 2 pages. What are the important point only? I have dragged to the slide. Who is empower MDCO? This was asked last before year. When this lookout circular came, last before year, the question was there for 3 to 4. Lookout circular, who can do? So lookout circular is for the persons who like fraudster and who is having certain exposure with us and as a part of a consortium. And he is going out like Malia, okay, Nirav Modi, like those cases. Those cases, after coming those cases, the government has given this guidelines to the bank. So MDCO is empowered to issue this circular, and this circular will be issued and given to the foreign departments and the customs and the airports to stop that person to go away, means from the country. Okay. The LOC and whatever the lookout circular is there, whatever we are issuing, it is valid for 1 year. So this can be the question. And whom we can give, the person and entities combined loan outstanding FB, non-FB put together not less than 10 crores. Okay, 10 crores and above only you can do this. Not like that 1 lakh person is given and you give the lookout circular. No, it is 10 crores and above. And in case of consortium, I told you these two parts are important, 10 and 50. In case of consortium and multiple bank accounts, the 50 crores and above when the exposure is there, then in those cases, parties where we have declared the fraud or there is a, in fact, red flagging has done, that also parties fraud declared, red flagging has done. In those cases, we can go for a lookout circular. And Deputy General Manager overseeing RR section, Wing HO shall be nodal officer for the purpose of issuing the request. So he'll be accept the request, and after that, final MD will sign, and that will send to the respective department to stop the person to fly. Okay. Now coming to the again recovery agent policy on the recovery agent, I have dealt with the surface agents. Now it is a recovery agent. So recovery agent means he can recover both recovery agent can be the surface agent or the recovery agent. So recovery agents of the part are there can be surface or recovery, but depending on the policy we have changing. Surface agent means they are specifically dealing surface, and recovery agent means they can deal with the small accounts also, doubtful loss accounts also. We can assign them to deal with. Okay. So there are two categories. One is retired government employees. You can take as a recovery agent, but their case is 50,000 deposit. This was the last before year case question, 50,000 deposit. And second is recovery agent who is not any retired government. Yeah, there they have to deposit the caution deposit of 1 lakh. Okay, other than retired staff and surface agents. Okay, they can do 1 lakh deposit. So recovery agents has to go to the courses, 100 to 50 hours courses. It is mandatory for all recovery agents, okay, through IABF. And BCA, if any BCAs are there, you want to make it as a recovery agent, that also we can do, but they have to undergo the training of 100 hours if it is 10th standard, graduation above 50 hours, okay. So and GNCSC and CBOA are empowered to do this agent. So just information, 50,000 deposit for the retired employees, non-retired employees, 1 lakh deposit. And what is the course hours? 100 hours course hours. For BC agents also 100 course hours. If it is 10th pass, he is a graduate, then it is a 50 hours. Okay, and depending on the case to case basis, we have to give. Okay, this is as per the 554 amendment which I have brought. I have made one striking of the line here. I have intentionally made it to strike off the LA. What is that? RO head is delegated to power enters the recovery and seizure. Okay, they are giving. And which loans can be given? So previously our circular as per 247, it was doubtful loss, including the substandard accounts. Here I mentioned substandard accounts, see, and including repeated restructure accounts. Right now, 554 has come, which has given the modification in July, that only doubtful and lost to be. The circular number also I have quoted here for the reference. So this is one change because the examiner may think to ask. So that is why I have brought into the picture into the slide. So 544, as per the 544 circular, the examiner may think that is important. So this is the one part where we can ask that which are the accounts can be assigned to the recovery agents. Okay. So seizure also will happen to the seizure of the vehicle seizures we are doing to the recovery agents. So when we are doing the seizure, you see that recovery agents assist the bank for sale of asset by identifying the borrower may pay a recovery agent up to 5% subject to maximum 25,000. So whenever any seizures we are giving in the form of a vehicles and all, so 5% of the subject to maximum 25,000 to the net sale price. What are the sale price is happening? 5%. Okay. And last year question, important. Borrower's calling time, 4 to 5. This was the question. 8 a.m. to 7 p.m. It was asked what is the time? 6 a.m. to 7 p.m., 7 a.m. to 7 p.m. like that. So that was the confusing. So everybody ticked whatever they liked, but it is 8 a.m. to 7 p.m. This time you have to be very careful while giving. The last year it was asked. So that is why I have highlighted here. And when paying to the fees, again, fees payment, last year the full questions was all like this only, fees payment, what is the fees payment, what is the percentage payment and all. So whenever we are paying recovery agent, 2% of the amount required for substandard, doubtful 5% of the amount. Loss and bad debt recovery if you have made means 10% of the amount required. Okay, maximum that 5 lakhs stipulation is there. In the first slide, I already told 5 lakhs maximum is to be payable. Okay, maximum fees payable to recovery in case of the settlement account by way of compromise. So he is bringing OTS. So we can give the 50% of the amount mentioned in the part A. That is what is the part A. So doubtful asset he has bring, so 2.5%. Loss asset he is bringing, 5% we can give. Substandard asset is giving, then 1% we can give. So depend on case to case basis. So substandard we can not go for OTS, but I already told in case of agriculture repeated restructure, then substandard account can be touched. And in other cases where party diseased or something like that, in the severe cases only substandard account we can touch to close the account. Okay. What is the step-up fees paid for the recovery agents now? Step-up fees can be paid if the resolution of the recovery is done within a time frame of 3 to 6 months. So you have given some accounts, very critical accounts, where the recovery agent has got the recovery within the time frame of 3 to 6 months. So in that case, we can do is, so in respect of assignment of recovery beyond 5, the fees payable shall be under. So what is the under? That is 5 up to 10, that is additional 5%, and 10 up to 15 borrowers, it is additional 10%. So whatever we have given the assignment that is beyond 5, the fees payable as per this. We have given some assignment, he has brought more. So if we are bringing more borrowers into the picture, then we can give this incentive. But maximum cap limit, you should remember, it is 5 lakhs. Additional incentive, which I already told in the circular, that maximum additional incentive, that 2 lakhs can be done. Now, again, the Caesar fees, once again, I'm just making for two-wheelers, it is 2,000. Two and two, it is very easy to remember. Two-wheelers, 2,000. Auto rickshaw, three-wheelers, it is 3,000. Okay. Car, jeeps, it is all four-wheelers, 4 into 2, 8,000. So this is the way you can remember. Buses and lorries, 10-wheelers, 8-wheelers will be there. So that will be the difference. So this amount only you have to remember. Two-wheeler, auto rickshaw, three-wheeler, 3,000. And car, jeep, it is having 4 into 2, that is 8,000. And 10,000 only you have to make. So RO head is here having the additional permission that he can permit for the additional 4,000 to the if a case to case basis, not in every case. Okay. Now coming to the concept of one chapter, ARM branch, very specifically I will tell. ARM branch headed not below the scale 4. Usually AGM only said so, but it should not go beyond below scale 4. So scale 4 and above are to be head the ARM branch, and it is a specified branch for specifically taking care of the NPA accounts. The accounts, what are the eligible? Suppose in your branch, it is also information to you in your branch. If you want to get rid of the NPA recovery, if you have the accounts, suit file accounts more than 20 lakhs at a reasonable distance, you transfer this file to ARM. They will take this file. So you call them, they will collect everything. They will take the processes and do the collection. Suit filed account, book liability of 1 crore and above to be transferred to AR. And 1 crore above anyhow has to be done. And 20 lakhs above is the criteria, you can do it. Even if it is operating distance. So here 20 lakhs, I told that here reasonable distance to be there. Means an ARM in Chennai is there, then you can take the nearby Chennai area 20 lakhs. But ARM in Chennai cannot take the Salem branch any account. Why? It is very distance 20 lakhs. Then if it is 1 crore above, then you can go and take that file and they will transfer that file to this. And it also reduces your NPA, but also reduce your business also. Business of the branch also to be reduced. Okay. So who can permit it? Circle head within the same circle. If it is intra circle, then it is a wing head. Suppose a file from Chennai circle has to go to Madurai circle means wing head has to permit. If within the circle file means circle head can permit. What are the exempted accounts for the ARM? That is accounts which is fraud, accounts settled under OTS, which is under the OTS agreement, which is not within the reasonable distance, I told already, amount, which have book liability less than 50 lakhs, not eligible for surface action. But 50 lakhs is less than 50 lakhs, but there is no surface available, means plots of any plots, anything, because everything is sold off. Accounts having NFB liabilities yet to be crystallized. So, whereas the NFB liabilities are there, which is yet to be crystallized, means NFB, it is invocation has happened. So, those cases can be taken into the consideration for transfer into ARR. So we are almost reaching to the end point. So 1,15,000 and last 5 minutes I may keep for the discussion in the form of a chat if you want. So this is also one important slide which I put in the last year from the detective agencies. There are 5 questions, scale 4 to 5 and also 3 to 4 and I think 2 to 3 also they have discussed this question. What is detective agency and who is empanel? So we can empanel the detective agencies case to case basis, like some big loans, education loan, you are not able to trace the party. Okay. You have no properties, nothing. So how you will do? So some detective agent service you have to take to entrust them and to do the needful. So who can do the empanelment? How it can do that? This is as per this. Minimum experience for detective agencies who are there is 3 years. So 3 years minimum experience should have, and they can be empaneled as a detective agencies. Okay. Where and it is not like we are empaneling it for the services taken to the every account. It is a case to case basis we have to do. Minimum, what is the size is 50 lakhs. You just see here it is mentioned. 50 lakhs and above cases only we are usually engaging the detective agencies to do the identify the borrowers or their lines. Like usually sometimes happens the big short accounts we are doing where we want to make a attachment before judgment in India. We don't have a proper securities. We have only 20 to 30 lakh securities. The other securities he is having, but we don't know. So for getting the details on that, for attaching the properties, we take these services. So this is happening in that way. This is what last year it was asked, fee payment to the detective. What is the minimum fee payment to be made to the detective agencies? Okay, who is investing? Minimum fee per person per borrowing unit company is 5,000. On receipt of information about whereabouts of the missing absconding borrower, 10,000 per person, subject to maximum fee 30,000. Suppose there are 3 persons in the account there. Okay, so sorry, 4 persons in that account. We cannot pay 40,000. 4 persons in that account missing. We have given the interest at that account, that wife, husband, 2 children, so 2 daughters or son who has taken the loan and who has been a part of it, and we are not able to trace them. So these cases can be done. For locating properties other than details which are available in bank records, which may lead to, just now I told ABJ attachment before order. So for those cases, we can interest and we can give 25,000. Providing any other information such as firms, companies where borrower is involved, which is helpful to banks to take the total that 5,000 per information such as maximum 20,000. So this chart you have to remember, because this chart only last year it was asked from the detective agency side. Okay. So this is all about the recovery policy in very crisp, which is the important point I have discussed. Some few more small chapters where there right of recompense and all, which is not find very important, maybe useful for studying, not very important. There we have, and also in OTS was the major part in that. OTS, I think Sarah has already dealt with. So where the OTS is there and all already we have seen. So those cases, case to case, you have to remember the charts OTS, the special one-time OTS and all. One OTS only I have discussed about the agriculture because that is a change. Expected questions may be there from that. So this is all about the recovery policy which we have to do. Recovery is not only giving us the highlight of the recovery is that if you really want see the improvement in your branch business or you can say the profitability, you see the recovery part. It will give the suppose say 1 crore account in your branch is there, which is a D3. 1 crore D3. Just remember 1 crore D3. So you have recovered in the form of a OTS. I'm just telling the importance how recovery is going to important. 1 crore account, which is in D3, which is giving the 100% provision. It is you have recovered. That 1 crore you have recovered, say 80 lakhs, not even 1 crore, 80 lakhs recovered. That also how fruitful it will be. So when we are recovering 80 lakhs, we are sacrificing only 20 lakhs from our pocket. It means we are giving 20 lakhs from our profit and we recovered 80 lakhs. So this 80 lakhs when it has come, 80 lakhs has come is our profit. This 1 crore, which was the provision which was held, which was in lock period, that has been released, means 1 lakh 80 crore, 1 crore 80 lakhs has been total profit you have got for that month for that account if you're settling for 80 lakhs. So there lies the importance of one-time settlements and the recovery. When you're recovering this type of accounts, it is not only giving the bank a boost to run, but also making your branch to make profitability. That 1 crore 80 lakhs profit, if you want to give, you have to minimum sanction at least 18 crores of the loan in your branch in on that month. Then only you can earn that 1 crore 80 lakhs. Okay, 18 crores if you want to 18 crores you have to give sanction and he has to utilize that limit for full month. Then only that much of interest is going to earn by the bank. So when we are doing this recovery, we are making in one shot. So that is what the importance which I can tell from the our side. So recovery policy from my side is this much. So I'm stopping the screen share. The forum is open for you. If you anybody is in the chat mode want to ask any questions, please you're open. I'll try to answer. We will take just more 5 to 10 minutes, then we can end this session. It's already 1:20, so I'm completing by 1:30. So in 10 minutes more, any questions from your side on this session, please. So in between, you can also, like if you have any queries, you can raise the queries through. I will tell CBO team to share my number. If you have any query, you can just make a WhatsApp. I can just assist you and whenever it is required. So being in RO, I just pulling paid borrower in guarantor case. As per 125 for guarantor, if he is a guarantor of the loan which is settled, it is not there. If it is a guarantee, it is not there. As per 125, guarantor, if he is a guarantor and that account is settled, then need not to consider. Somebody user, you have question. Good question. 125, please, you want to take a look on that, please go to the 125. It was very good. PPTs will be shared with CBOA team and it will come into the video, I think. That will be done. Okay, then no questions. The staff of a bank can participate in e-auction. Yes, with proper permissions. E-auctions can be done with proper permission. Okay, where they will check it should not be relative and all those things will continue. Fresh finance of agree up to irrespective of the cooling period. Fresh 50,000 is irrespective of cooling period. Yes, thank you. That's a good question. Abarna. Principal only interest as well. What is I'm not getting Jyoti's questions. That principal only or interest as well. When loan will be NPA 90 or 98? On 91st day it will be NPA, not 90. 90 days of time. On 91st day means EOD of 90, it will be NPA. So on 91st day it will show as NPA. Interest to create security. Which document number to be mandatory to take an unregistered mortgage? For unregistered mortgage, that is why you take LETD documents. That is 460 and 461. That is the document which we take for the creating of the interest of securities. Advances to auction properties allowed. Yes, it is very well allowed. But whenever you are giving advances, once again, I am telling somebody asked very good question 83505. When you are giving advances to the surface properties, ensure what I told that suppose sometime it may happen it is our surface property, sometime it may happen other bank surface property. Last just 1.5 week back I have sanctioned 1 crore 50 where we have ensured that all the proceedings from that bank we have taken 13.2 13.4 paper publication account we have taken very intact and we have included in our LSR and we have told our lawyer to give specifically on this point that SARFAESI is enforced and it is correct. Then only we can give loan. Then he has made it, then we made it. SARFAESI 20% rentals are not taking SARFAESI action, sir. What is the 20% meaning is if I just given the example, if the amount is 20 lakhs, you have sanctioned for one customer, say 10 years back. On the 11th year, suppose the 8th year he has come and the amount has come to some 3.5 lakhs, means 20% of the 20 lakhs is only 4 lakhs. So now, right now, liability is 3.5 lakhs. So you cannot go for the SARFAESI for that account. When servicing the notice through email, you have to again send the notice registered port to that address. If you can send a very well SARFAESI notice email. Keep that email copy intact, but you have to again send the registered port copy to the borrower, and you have to keep it. If SARFAESI is going on, can we do OTS if customer requires? Yes, very well. SARFAESI is going on. We can do OTS, but SARFAESI procedure should not be stopped unless and until OTS full amount is received. What is out of order account? Out of order account, we say in specifically in case of OD accounts where say OD you have given where no credits is there for 90 days, that is out of order. OD there is no limit for 90 days, out of order. OD interest is not servicing, the interest servicing is not happening, that is out of order. Stock statement he is not submitting, it is out of order. Okay. Margin and lendable amount, so many questions, but it is moving up and up, up and up, up and up, up and up. So wherever I am in for book liability calculation, which first path you are using accuracy? Usually AC002, we are getting that book liability part. Okay, so don't worry. Or LNM 10 also, I think it is giving the. I am not very sure. This I have to see AC002, but you will get that path. Auction of the property second time within 15 days of the time. First sale was no success. We have to issue the once again the sale notice. Yes, my dear. E-auction, when you are doing for the second time also for 15 days, that time also we have to again issue a sale notice, and we have to give the time, that 15 days time, and we have to tell that this days will be the sale notice. Yes, very good question. Sale notice has to be given once again for the second time sale if 15 days for 15 days time also. Can customer apply for stay in DIT after banking test physical question? Yes, very well. I told my example only when I was taking the physical question, customer they have taken they have gone to the DIT for stay. It can be possible anytime. Any criteria for attachment under ABJ? There is no criteria. If you think that party is having another property and you can attach those property, we can take ABJ. Clarify contractual liability and book liability. Contractual liability is what the liability you're seeing in the CBS in 7026 part. It includes the unapplied interest also, like unrealized interest we call it. And book liability is the only principal amount, and in some cases it is principal plus our charges which is debited to the account. Now anyhow account debit they have stopped. If any charges is also debited, the charges and principal is our book liability. If purchasing auction, customer wants some time to avail advance for purchasing, how much time? That is as per the housing loan rules. If suppose for auction property somebody want to purchase, as per the housing loan, whatever the applicable, that only we can do. Caveat. Caveat is just in under, it is just clear again given to the DRT from the bank side that we are we are doing the positioning of the property. If the party approach for the stopping the DRT proceedings, please intimate us and then give the decree. Do not give the decree without intimating. I have given in my example, I told now the caveat was filed by us. Then only we came to know that party has gone to DIT for the stopping what is about the 20% for the initial payment on the day of auction? Initial day of auction in the case. What about the 25% initial payment on the day of auction? If the day of auction which we have given is say today, so today he has to pay that full 25%, means already he has paid the EMD in the form of 10%. But the rest of the 15% he has to pay today itself. If not today, maximum by tomorrow. Anyhow, today is Saturday, no, suppose say Friday, yesterday's sale happened, means by yesterday he should have paid the 25% of the initial amount of the whatever the property value we have set. If he is not paying the 20% by Friday, he has to maximum pay by Sunday, that next working day. Okay, that is the successful bid amount. Yes. Within how many days NPS should file should be done by the branch? There is no such case within how many days as per the policy not written, but the case to case basis, wherever the it is limitation is going to be over, you have to file the suit. If suppose you think that the account become NPA today and day after tomorrow it is the limitation is going to happen, means they have to do the suit. Okay, you have to file the suit. That is the criteria. Before the limitation period is over, you have to file the suit. Otherwise, we will not withstand the limitation. If legal hire is minor, then what about servicing notice? If legal hire is minor, what about the servicing the notice? We have to service to the notice if legal hire is minor. It's a good question, but I have to also think about this. I have to give the answer. I'm really no idea. It's a good question. Legal hire is a minor, whether we can serve the notice. Because legal hire, we serve the notice. Whether legal hire, we serve the notice. I have to speak with the law team. Aparna, you can share your number to our CBO team, or you can mail me. I shall share my mail ID. I think. Whiteboard, can you enable? I will share my number. Silva.
Yes, sir. Yes, sir.
Aparna, can you share that query? I will just reply you in the mail. Okay.
Sir, whiteboard is enabled now.
It's my WhatsApp number which I am sharing you. Silva, tell my number from there. The office number I am forgetting again and again. Nine double 450, right? 28304. Hello, is the number is correct? Silvaji? Yes, Silvaji.
Sir, number is right.
Okay. And
Sir, share it
also,
once more, sir. Your number is right, sir, actually. 502-8304.
somebody is deleting. Again, annotation, somebody is taking control.
Sir, disable it at your this thing, sir.
Yes.
Sir, whether your chat box is visible?
Okay, I'll put in my chat box.
Yes, yes, yes.
944. I've shared my number. You just WhatsApp me on this number the queries. I'll try to answer. And you can also mail me at Yes, dear friends, I have shared. So not making much of taking much of your time. Thank you very much for your patience hearing, and thank you very much for being the part of this session. And thank you very much for your appreciations for the class, and all the very best to all of you. We want to see the colorful results from the team who's attending this class. And again, awake, arise, and stop not till the goal is reached. Thank you very much.
Thank you, sir. Thank you
Okay,
for the
thank you.
lovely session.
Thank
With
you.
that, we
And
have covered a
also
lot of details.
thank you to CBOA team and giving the opportunity to me and may thinking that I am eligible enough to take the session. Thank you very much. Anand Krishnan sir, Ravi Kumar ji and all. Our Ravi Kumar sir is also my mentor. So thank you very much. And Disilva ji for giving the constant support through this session.
Thank you, sir. Thank you, sir. Thank you to you, sir, first.
Thank you.
Okay, sir. We will end the session, sir.
Yes,
Thank you,
please,
friends.
please, please.
Thank you, sir.